Wayne County Division 1.
Yes.
Yeah. Good morning. Hey, is there a way that we can get Mr. Bell? I have that attorney here for him, and I don't have the attorney for Mr. Graham.
Okay, hold on. You said Bell? Yeah.
Bell, then?
Yes, we have Mr. Bell. We're about to have him switch out.
Okay, thank you so much.
You're welcome.
All right.
And may I be placed in a breakout room with Mr. Bell before you call the case, Judge?
Sure.
Thank you.
Calling parties on Taylor. Oh, yeah, he's getting ready to sit down. Okay. Case number 2157658. The people of the state of Michigan, Gary Taylor. The defendant is charged with count 1, false pretenses, $1,000 or more, but less than $20,000. This is scheduled for a probable cause conference.
Thank you, ma'am. Appearance. Prosecutor.
Joshua Holman on behalf of people, P number 71971.
Good morning.
Good morning, Your Honor. Steve Mencken, P31562. I'm appearing on behalf of Gary Taylor, who's present.
Good morning. And Mr. Taylor, please state your name, sir.
Gary Taylor, Your Honor.
Good morning. Okay, today is a PCC. Counsel, what's your pleasure? Mr. Mencken?
Your Honor, I've sent in, he's going to waive his exam. I sent in the papers. He consented to me signing his name.
Okay, Mr. Taylor. Oh, well, first let me ask to the prosecution, is there any objection to the proposed waiver?
No, Your Honor.
Mr. Taylor, I just have a few questions for you. Do you understand the allegations against you, sir?
Yes, Your Honor.
Do you understand that you have a right to a preliminary examination?
Yes, Your Honor.
Do you understand that if an examination did occur, that the prosecutor would need to establish by a probable cause standard only that crime was committed in the city of Detroit, County of Wayne, probably committed that crime? Do you understand that?
Yes, Your Honor.
And if at an exam, the prosecutor were able to establish that burden, the matter would then be bound over to the circuit court for further proceedings. Do you understand that process?
Yes, Your Honor.
So the representation was made here by your attorney, Mr. Minkin, that you wish to waive, to give up your right to a preliminary examination. Is that true, sir?
Yes, Your Honor.
Do you understand that means that the matter will automatically be bound over to the circuit court for further proceedings without the benefit of an examination?
Yes, Your Honor.
And again, I wish to And again, is that how you wish to proceed here today?
Yes, Your Honor.
Thank you. And are you doing so voluntarily, sir?
Yes, Your Honor.
Thank you. I do have the examination waiver form returned to the file, which appears to be properly executed. That being said, I do find your waiver to be knowingly and voluntarily given here. The matter will be bound over as charged with an AOI date of August 6th at 9 a.m. Is there anything further from either the prosecution or the defense?
No, Your Honor.
No, Your Honor.
No, Your Honor.
Thank you. Okay, we're all set here. Thank you so much.
Thank you, Your Honor. Have a good day.
Thank you.
Calling parties on Muhammad. Case number 2159143. The people of the state of Michigan versus Karaya Muhammad. The defendant charged count 1, assault with a dangerous weapon, felonious assault. This matter is scheduled for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Brent Bailey on behalf of the people, P84009.
And good morning, Your Honor. Neighborhood Defender Service by Elizabeth Young, appearing on behalf of Ms. Muhammad, who's present on Zoom right now. Ms. Muhammad, if you're able to hear, could you turn your video on and maybe unmute your microphone and say your name?
Good morning, Your Honor. This is Kyria Muhammad.
I'm sorry. Your name one more time.
Kyria Muhammad.
Thank you so much, and good morning to you. Okay, today is the date and time set for a PCC. Madam Defense, what's your pleasure here today?
Your Honor, Ms. Muhammad is asking that this matter be please be set for an in-person preliminary examination.
Okay. Discovery?
Yeah, I do. I believe I have both paper and electronic.
Okay. So, Henry and everyone, I need everyone to silence their microphones. Silence your microphones because it makes it difficult for us to hear from this perspective. Also, in the event that your case is being called and you're the defendant or a witness, before you speak, I need you to unmute, and then I need you to stream your video. So familiarize yourself with your devices to the extent that you know how to do that. Please make sure that you act with the same decorum that you would if you were inside of an actual courtroom. I know Zoom court is a little different of an experience for some of you, but my expectation is that you will be wearing clothes. You will be properly clothed.
Yes, ma'am. But can I check in?
Well, can you give me, Mr. Sanders, can you give me one moment?
Oh, okay. I'm sorry. Let me
That's
mute
okay.
this.
That's okay, thank you. So my expectation is that you would not use any profanity, that you would not have any outbursts, or act in any way that you wouldn't typically act inside of this physical courtroom. So with that being said, Mr. Leo Sanders, we're kind of in the middle of a matter, but you're checking in on a matter, sir?
Judge, that's actually scheduled for an in-person exam, so I'm not sure why he's on Zoom.
Oh, okay, Mr.
That's 10
Sanders,
a.m.
please make sure that you call your attorney, Mr. Bill Winters.
I
You're
don't have his
supposed-
number. I don't have his phone number.
Okay, we're gonna give it to you. Because you're scheduled to be here inside of the courtroom at 10.
Did they? I didn't know that. They didn't know. Nobody never called me and told me that.
Okay, I want you to call Mr. Winters. We're gonna give you the number.
313-510-3316.
Yes. 331. Okay, my twin brother. Do he have to come there today too?
You were both supposed to be here in person at 10 a.m.
Why my lawyer never told me anything?
We talked to him last night. Yes.
Okay. Can you give my twin brother Leon? Can you give me his lawyer number?
Attorney has already checked in.
I beg your pardon.
His attorney checked in. There's some special circumstances going on with him that I think he probably knows about, but you were both supposed to be here at 10 a.m. in the court.
She didn't tell us nothing yesterday.
So you want? Okay, so when we come to the courtroom.
We on our
We're
way
gonna give your twin
That
Ms. Mitchell's number,
her-
okay?
Her number is
Yes.
313-574.
Okay.
6670.
Yes.
Tell her I want another lawyer.
Okay. What courtroom is this? What courtroom again?
This is courtroom 233, Judge Archer.
Okay. Let me get ready to come down as fast as I can.
I can't believe this.
Okay. Thank you.
So,
Down my lawyer, you gotta talk to her. And that's the same way I
Well,
want.
yeah. Let me get off the phone first.
everyone, again, just a reminder to keep your microphones muted so that we can as swiftly as we can get through this docket. We're back on the matter of People versus Muhammad. Madam Defense, you indicated that you wish to have an in-person examination. Is that correct?
Yes, Your Honor.
Okay, so we need to select a date. She's not in custody. The record should reflect, Madam Clerk.
The reason I called is Ms. Young said she wanted to address the bond.
Oh, let's address bond then first, Ms. Young.
Thank you, Your Honor. Ms. Muhammad currently has a tether bond. And if I may, Ms. Muhammad is 42 years old. Prior to this case, she has no criminal history. This is a case involving an allegation regarding her son. She is no longer living with her children and in fact doesn't even know where her children are staying. No contact is not an issue in this case. She is grateful for the break that she is having from her children. And more importantly, Ms. Muhammad is working 40+ hours a week. She works for a delivery service that works under Amazon. It's like a contractor. And I'm looking out the window right now and it's pouring, right? So Ms. Muhammad has explained to me that for her work, she wears boots that lace up around her ankles and give her ankle support and also protect her feet from the mud, the wetness, and also from slipping, right? So as a delivery worker, she's wearing combat-esque type of boots, but she can't do that with the tether around her ankle. And also she's getting in and out of the vehicle frequently throughout the day. The tether is catching, it's really hurting her ankle. I'm asking that the court please remove the ankle around, or remove the tether around her ankle. And that is based on her lack of criminal history, her employment status, and the representations I've just made to the court.
Okay, that motion is going to be denied. However, I will hasten the exam date. As you know, Ms. Young, your client probably doesn't because most people are shocked when they hear the date where we are. We're in December. What I'd like to do is ask Madam Clerk to find a date somewhere early October, because the GPS tether, unless the prosecution is acquiescing to removal of the tether, the GPS tether is put in place for a reason. I've had an opportunity to review the report, and there's nothing that has been said on this record, notwithstanding the representation regarding employment and the boots, etc. There's nothing that's been said on this record that makes me feel comfortable eliminating that requirement, given the allegations, which are very serious, whether it's a family member or not. I'm troubled by that, and I want to make sure that the second prong of that bond analysis is covered, which is the safety of the community at large. I do not feel that the grading magistrate abused their discretion in imposing that requirement. So I am going to keep that on as a deterrent to make sure that we know where the defendant is and to make sure that the defendant is having no contact whatsoever with the complaining witness. Madam Clerk?
October 8th at 9:30.
That's a good day for the defense.
Okay, October 8th at 9:30 in the morning is going to be the in-person examination. Ms. Muhammad, are you still with us?
Yes, ma'am.
As you can see, can you run the video or is that a problem?
I can. I'm stationed right now.
As you can see, I don't know if you were listening to the gentleman that interceded in this hearing. He was supposed to be here, is supposed to be here at 10, and he was on Zoom. So that's why I always try to stress that everyone marks their calendar and that you understand that your presence is to be requested not on Zoom, but inside of the courthouse here at 9:30. There will be likely, I'm assuming, screening process to enter the courthouse. Please make sure you allow enough time to pass through that screening process so you are not delayed when the case is called. Please make sure so that you continue the no contact provision. I understand you have the tether on, but make sure there is no violation. That would include indirect contact as well. And I'm not certain, sometimes I feel as though that's not explained thoroughly. So make sure if you have any questions about any contact that you speak with your counsel about it. And that would include even if the complaining witness comes to your doorstep. You are not permitted to engage in any form or fashion, not even through another individual to speak to that person. You understand?
Correct. Yes, ma'am. Those things are already cleared out for me.
Okay, perfect. All right, thank you so much. And Ms. Young, was there anything further?
Nothing further. Thank you, Your Honor.
Thank you.
Ms. Muhammad, you're all set, and we'll talk in the future on the phone.
Okay, thank you.
Okay.
Bye.
Is that someone different to the jail or is Miss Nance back?
Ms. Nance, do I need to pull
I'm
your
here.
client?
I'm here, Judge. That's
Hi,
Mr. Bell.
do I need to pull him back or is he there?
He's there, Judge.
Oh, okay, thank you.
Calling parties on Bell, Case number 2058428, the people of the state of Michigan versus Melvin O'Neill Bell. This matter is, I'm sorry.
I believe it's listed on the docket as a review.
Yeah, I'm just trying to find the complaint so I can read it. The defendant is charged with count 1, weapons, firearms, possession by felon, count 2 and 3, assault with a dangerous weapon, felonious assault, count 4, 5, and 6, weapons, felony firearm, habitual offender, fourth offense notice. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
And good morning, Judge. May it please the court, Janecki Nance, P68686, appearing on behalf of Mr. Bell, who's appearing from the Wayne County Jail. Mr. Bell, would you please state your name for the record?
Melvin O'Neill Bell.
Judge, and we do
Thank you.
consent to have this hearing conducted via Zoom as opposed to being physically present in the court. Judge, today on this docket, it is scheduled for a probable cause conference. Previously, this matter was before the court with the same docket number. A capias had been issued on this matter after I had requested a competency examination. We went through a litany of things trying to figure out where Mr. Bell was. He had been transferred to DMCA hospital. He was administratively, some type of way administratively released from the Wayne County Jail, and we could not locate him. He has been picked up. At this time, Judge, I am still renewing my request to have him evaluated for competency.
Okay, so that would put us 90 days out. What date might we be able to set?
October 15th.
That's a good day for me, Judge.
We will make the referral for competency, and the competence review date will be October 15th at 8:30.
Is it for competency only or criminal responsibility as well?
Actually, you can go ahead and do both. Thank you.
Okay, was there anything further?
No, Judge, thank you.
Madam Prosecutor?
No, ma'am, thank you.
Okay, we're all set. Thank you so much.
Thank you very much. Everyone have a great day. And Mr. Bell, I will see you this afternoon for a jail visit.
Okay.
Calling parties on Coleman, case number 2155836, the people of the state of Michigan versus Andrew Coleman. The defendant is charged with count 1, controlled substance, possession, cocaine, heroin, or another narcotic less than 25 grams. Habitual offender, fourth offense notice. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good morning, Your Honor. Warren McAlpine, P number 52522. I'm here on behalf of Andrew Coleman, who is not present.
Okay, and Mr. Coleman is not in custody, I assume?
No, Your Honor.
Are you requesting to waive his presence?
Yes.
Okay.
I object, Your Honor.
Oh,
This is the third PCC that we've been here, and Mr. Coleman has not appeared for a single one of them. I'd ask for a capias at this time.
Mr. McAlpine, have you had any contact with this gentleman?
I have not, Your Honor.
Okay, not even at the onset of your initial appointment?
I never saw him, never met him, never spoke with him.
Okay, this is, I see, there was a PCC on May 20th, also one on June 17th, and on today's date, and I'm not sure if there's any dates that I'm missing from my notes here, but I noticed that the defendant has not been here. And I'm sorry, were you saying something?
I have April 23rd as well.
Oh, okay. and the defendant has failed to appear. So given that information, that you have had no contact with the defendant at all, that does worry the court, and I am going to grant the motion for a capias.
I understand,
Please.
Judge.
You do get in contact with the defendant. Please be aware that after about 3 p.m., 2:30 or 3 p.m., the capias actually will be entered, and he will need to avail himself in the traditional manner of anyone that has an open warrant.
Understood.
The previous bond is going to be revoked. And a new bond is going to be set at $5,000 cash or surety.
If I speak with him, I'll let him know, Judge.
Thank you so much, Mr. McAlpine. Have a great weekend.
You do the same. Take care, everybody. Bye.
Three 233 Okay, okay, all right. Wayne County Division 1, what's your name, sir?
Will Morris.
Okay, thank you. Calling parties on Hargrove. Case number 2159152, the people of the state of Michigan versus Kevin Lamont Hargrove. The defendant is charged with count 1, malicious destruction of personal property, $1,000 or more, but less than $20,000. Count 2 and 3, domestic violence, habitual offender, third offense notice. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Good morning, Your Honor. Jacob P77307 on behalf of the people.
Good morning, Your Honor. May it please the court. Robert Plumpy, P22965, on behalf of Mr. Hargrove, who is present via Zoom, and we agree to have this hearing by Zoom.
Thank you. Mr. Hargrove, please state your name.
Kevin Hargrove.
Thank you. Mr. Plumpy, what's your pleasure here today?
Your Honor, we're today and we are demanding a preliminary examination in person. Thank you.
Mr. Bloomers, are there any concerns that you have regarding bond that might affect when we set this for an exam?
No concerns as to bond from the people, Judge. The people are satisfied.
Okay. It was just one month.
October 11th at 11:30.
October 11th at 11:30.
That should be good, Your Honor.
Okay.
Did you hear that, Mr. Hargrove?
Yes, I heard it.
Okay, so Mr. Hargrove, the expectation again is that you're going to be here in person at the courthouse and in this courtroom. Please make sure you arrive in advance to pass through any screening that will be necessary that often causes delay. Mr. Plumpy, you have discovery?
Your Honor, I'm not sure because my office is undergoing extensive renovations regarding updated technology of the most modern degree. So if I don't have it, I'm sure I'll get it by the 11th.
Okay. Well,
And Judge, I guess I'll just say for the record, I did send a link for the paper at about 8:30 this morning, and then I will follow up with digital.
Thank you.
okay, perfect. Bond will continue. Thank you.
Have a safe and good weekend, Your Honor.
Two.
All right. Bye-bye.
Calling parties on Jenkins. Case number 210575491. People of the state of Michigan versus Derek Jamal Jenkins. The defendant is charged with count 1, weapons, firearms, possession by felons. Count 2, weapons, ammunition, possession by felon. Count 3, weapons carried concealed. Count 4 and 5, weapons, felony, firearm. Habitual offender, third offense notice. Judge, this matter is scheduled for a preliminary exam in October. It was asked by the prosecution to call today in order for a dismissal to be called.
Appearances, please.
Good morning, Your Honor. Brandon Bailey on behalf of the people, P84009.
And good morning, Your Honor. Matthew P73168, appearing on behalf of Derek Jenkins for his attorney of record, Ben Gonick.
Okay, and Mr. Jenkins? Mr. Jenkins? Did you want us to pass on the matter?
Mr. Jenkins, are you here?
2282.
You can't, and you know, that's why I say, you know, you never know.
I can actually say now I've heard it all.
You never know what you're gonna get. Thanksgiving.
Happy Friday.
Happy. Who said that? Who said happy Friday? TGIF. Okay, so as a reminder, everyone could keep their microphones muted. That'd be great. And also, yeah, just please. Mr. Magidson, I'm please. Oh, I forgot what we were doing. What are we doing?
Trying to dismiss the case, Judge.
Oh, okay, is Mr. Jenkins here, or was that Mr. Jenkins?
I'm not sure, Judge.
Would you like to pass on the matter, or are you requesting to waive his presence?
I'd ask the court to waive his presence at this time.
Sounds like somebody was passing.
So ordered. Okay. So on People versus Jenkins, what are we doing here? Let's get back to business.
Yes, Your Honor. The people are moving to dismiss this case without prejudice. The reason being is the federal government has filed an indictment with the federal court system, Your Honor. So the people will be dismissing so that the federal government can take over jurisdiction.
Okay, and I know, Mr. Forrest, you being the thorough attorney that you are, that you will communicate to your client exactly what is going on here today with regards to this, before this court, and also what you might expect in the future. It sounds like the ball has already started rolling in regards to what Madam Prosecutor just said. So I do need, Madam Prosecutor, your signature on this. I'm gonna check off the last box titled Other, and if you could fill in that information you just indicated so that the basis is clear. And if you could provide your signature as well. The matter is dismissed without prejudice. And we're gonna make sure, Mr. Forrest, that we forward a copy to you as well. Is there anything further?
Thank you, Judge. No.
Okay, we're all set here. Thank you.
Have a nice weekend.
Yeah, you too. Calling parties on King, case number 2062599. The people of the state of Michigan versus Dontel Alonzo King. The defendant is charged with count 1, weapons, firearms, possession by felon. Count 2, weapons carrying concealed. Count 3, assault with a dangerous weapon, felonious assault. Count 4 and 5, weapons, felony, firearms, second offense notice. Habitual offender, third offense notice, commission of a felony with a motor vehicle advisory. Judge, this is scheduled for an exam on Monday, but defense counsel asked to call it today.
Okay, appearances, please.
Good morning, Your Honor. Brent Bailey on behalf of the people, P84009.
Good morning, Your Honor. Mark Magidson on behalf of Mr. King, P number 25581. And yes, I did contact and reach out to the court earlier in the week for the reason that when this was set, I had neglected to put on my calendar the fact that we had a prepaid vacation as well as airlines tickets to a destination in the Caribbean. And so I once I realized this error, I contacted the court, and here we are. So I'm asking, regrettably, for an adjournment of this exam to, if the court would allow me.
Is Mr. King present?
Well, no, I tried to reach out to him, and he knows about the 19th, but I couldn't reach him last night or this morning.
Well, I certainly understand. I certainly understand how that can happen, although I'm certain your family wants to know how you could possibly forget this wonderful Caribbean vacation.
Well, okay, so normally I have a legal assistant who kind of operates my business calendar. She doesn't operate my personal stuff, so that falls on me. So you can see what happens.
No, I'm just kidding. So certainly I do find good cause. I'm not certain if the prosecution wants to object or not, but she may make a record if she'd like, but I'm going to find good cause to adjourn this to a date where the defendant who's not in custody. My only concern is that he's not present right now, and I just want to make sure that you make continued efforts to get in touch with him, to alert him that he does not need to appear here in court on the 19th.
Oh yeah, we will do that. And
Madam Prosecutor, did you want to object?
No, Your Honor, I'm not going to object. Just ask Mr. Magnuson to take me with us.
Yes. bring back some sand or a shell or
You can
something.
object to the beach. Does October 12th at 11 a.m. work?
let me quickly check the should. That works.
Okay, tell me again, October what?
October 12th at 11 a.m.
October 12th at 11 a.m., new in-person examination date. Again, please make sure that Mr. King is made aware, and I'm certain the prosecution will in like manner call off their witnesses. And are there any concerns regarding bond for Mr. King in the meantime?
The people don't have any concerns at this time, Your Honor.
Okay, we're all set here. Thank you, Mr. Magnuson. Have a great vacation.
Thank you, Judge. Thank you, everybody. And I'll try. You have a good weekend.
Okay, take care.
I'm gonna call these two quick. Is this gonna go?
I'm not sure.
Okay, let me call these two real quick. Calling parties on Dawson. Case number 2158289, State of Michigan versus Anquan Dawson. The defendant is charged with count 1 and 2, assault with a dangerous weapon, felonious assault. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Nicole Sadi, P74238. I represent Mr. Dawson. Judge, Mr. Dawson contacted me last night to let me know the camera, the front camera on his phone was broken. He did appear by video last time. He is on the Zoom, but he's at work. So we're requesting that a phone appearance, I suppose, instead of the video appearance.
Okay, Mr. Dawson, can you state your name?
Hey, good morning. Antoine Dawson.
Okay. What is your pleasure?
So last time we adjourned for video discovery, I did get that over a week ago, I believe, on July 8th from Mr. Bloomers, and I was able to download it, but I've been unable to find the time to adequately review it. So this time defense is asking for an adjournment.
Of the TCC, or because, even if we set an exam date, it's going to be quite a ways off.
It does look like a case when I looked at the paper discovery where we would set an exam. So if Mr. Bloomers is open to, I'm sure he would be talking to me in case that changes while I review the digital discovery, we could do it that way.
So you want to set the exam date?
Yes, please.
Okay, all right. Are there any concerns regarding bond that might affect the timing of the?
No concerns as to bond, and this is at least a second PCC, and there have not been any issues with bond, so the people are satisfied.
Okay, can we have an October date, please?
October 13th at 9:30.
Yes, that should work for myself. Mr. Dawson, does that work for you?
Yes, ma'am.
in-person examination here in courthouse, October 13th at 9:30. And if there are any concerns, Ms. Sadi, you have regarding that digital discovery, or if you in the interim wish to waive exam, there's going to be plenty of time for us to address any concerns or any resolution prior to that October 13th date of exam, okay?
Thank you so much. Everyone have a good weekend. Bye.
You too.
You too. Thank you.
Thanks.
Calling parties on Hensley, case number 2158255. The people of the state of Michigan versus Latia Michelle Henley. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, domestic violence. This is scheduled for probable cause conference.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Good morning, Your Honor. Kathy Murphy, P51422, for Ms. Henley, who is present. She was present.
Please state your name.
Oh, there she is. Ms. Henley, will you state your name? Will you unmute and
Latia
state your name?
Henley.
Can you turn on your video?
Latia Henley.
Hi.
Thank
Judge,
you.
we have discovery and we are requesting a live exam.
Judge,
Yes.
before we set a date, I'm sorry, the complaining witness is here on the Zoom, Willie Smith, and I was hoping to get a breakout room just to make sure I have a chance to talk before we go off the record in this.
Absolutely. So you can do it right now, and then we'll recall it as soon as you return.
Thank you, Judge.
Ms. Henley, I'm going to call you right now, okay?
Mm-hmm.
Okay, so we'll be standing by, Judge.
Thank you.
Mr. Simon, are you checking in on Cody Hawk?
Yes, I am. I just left you a chat.
Oh, okay, I didn't see that.
Who's that in Wayne County, Division 1?
I think that's Mr. Morris and Mr. Baker.
Mr. Hunt at the Department of Corrections. I think Macomb.
Go Morris.
Okay, thank you.
Okay. So is this, all right, so we'll call it at 10 then.
Okay, I'm in like 3 other Zooms. I'll get back with you at 10 then, okay? Is that what you like?
Because we're not gonna call it before it's scheduled.
Oh, that's fine. That's fine. I'll see you in a little bit. Thank you.
And I know you're here on Rissenbat, but we can't call it until he's brought to the video. And are we ready on Torbert? Where did everyone go?
They just stepped out. I'm sure they'll be right back. They just wanted to talk for a minute.
Oh,
I'm
okay.
ready.
We're gonna try and bring them back.
Yeah, because we have things to do.
Your Honor, would you like Rissenbat
Yes,
in front of the camera?
Say again?
Would you like Rissenbat in front of the camera?
I guess if you want to switch them out, you can. We also have, Mr. Quinn is here on Mr. Graham.
Okay, thank you. I'll put Rissenbat and then Graham.
Okay, thank you.
You're welcome.
I'm the prosecutor on Graham Simona. Good morning. I'm here as well.
Good morning.
Oh, okay. Check in. Calling parties on Torbert.
Ready, Your Honor.
Case number 2062238. The people of the state of Michigan versus Jalen Marcel Torbert. The defendant is charged with count 1, license documents, plates forgery. Count 2, license documents, plates forgery. Count 3 and 4, license documents, plates forgery. Habitual offender, second offense notice. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Jacob Slusky on behalf of the people, P83677.
And good morning, Your Honor. Gerald Ferry, P44630, on behalf of Jalen Torbert, who's present in the court. Sir, could you please state your name for the record?
Jalen Torbert.
Thank you. And today's the date and time set for an examination. Are we proceeding to an exam?
Your Honor, if I may, as a preliminary matter, I had a discussion, actually several discussions with my client regarding this matter. There was an offer to try, made by the prosecutor that to resolve these. This offer, I believe, is extremely generous. I made my client aware of that offer. not only yesterday, but also this morning. It appears that he's rejecting an offer, and he's asking that I withdraw as his attorney. So I'll leave it to the court's discretion, but there does appear to be a serious breakdown of client-attorney relationship here. If the court's not inclined to do that today, I'm ready to proceed.
If the court is not inclined to do what?
To allow me to withdraw and reschedule this matter for another exam and appoint substitute counsel.
Well, Mr. Torbert?
Yes.
Given what counsel has just indicated here, are you asking for a new attorney because you feel that you cannot proceed with counsel that's before you?
Yeah, I didn't have enough time to really talk to him during the pandemic. It's just like, I reached out and then at the very end, it's like, I gotta make a decision that, you know what I'm saying? I really want to try to find justice in it. I just don't really want to plead to nothing that I feel like, you know what I'm saying?
Yeah, so I just want to make sure that we're proceeding in a manner that is helpful and consistent with what's being presented. Are you saying that you feel as though there's a breakdown in the attorney-client relationship, or are you saying that you just would like some additional time to speak with counsel?
I feel like it's a breakdown. It's not no problem there. It's just that I didn't have enough time to really talk to him. He just also right here at the end of the day, like I reached out beforehand. I just got my discovery packet yesterday. This has been a matter from all the way earlier in like the last year. So it's like it's just getting stuck through on me, and it's like this is my first time really, you know what I'm saying, seeing my discovery packet just yesterday.
Do you feel as though if you were to be given a short adjournment of this matter, that would afford you an opportunity to speak with counsel and review the matter? And the reason why I'm asking these questions is before counsel is released, I just want to make sure that we're proceeding in a way that is going to be, again, helpful to this process, as opposed to just putting a new attorney in the matter. Counsel that you have assigned to you is tried and true, and knows exactly, knows the system very well.
Yes, I got one question, just to like kind of clarify. If I take this plea, will it really hurt me? Like, will I be a third habitual and all that? Like,
Well, unfortunately, I can't unzip my robe and be a party to those sorts of conversations.
Yes.
That is what counsel would be here for. Now, if you feel as though he's not answering the questions or counseling you to the degree that you're satisfied, now that's something different. But it's improper for me to unzip my robe and come around, and that's what I would have to do in order to answer those questions.
Your Honor, if I may I place something on the record?
Sure.
With the prosecutor's permission? And just for the record, I did have, it wasn't just that I called my client late at the last minute yesterday. I had opportunities to speak to my client. I did provide him with discovery, and in all honesty, exactly the most intricate of facts as far as a charge. But right now, Your Honor, my client's charged with 4 felonies, license forgery, maximum of 5 years as a second habitual. Prosecutor's making an offer, I believe, and it's still valid, that he would dismiss all of that in exchange for a plea to a 93-day misdemeanor of no authorized license on person and a 93-day misdemeanor of an invalid license. I believe that's the offer. Am I stating that correctly, sir?
Yes. I do want to check though, let's see here. I believe, so unlawful use of a plate is a 90-day misdemeanor. That's a 3-day difference.
Oh, yeah. I mean, either way, it's, as the
In
Godfather would say.
lieu of felonies.
All the felonies in the habitual would go away. We would have 2 90-day misdemeanors. I explained to my client that because they're misdemeanors, the habitual is not going to be any part of that. And I also explained to my client that the felonies were going to be or go away, dismissed, and those would not be part of his record. Essentially, these are, as the court's aware, and I'm aware, certainly we practiced together for quite a number of years. moving traffic violations that occur almost every day. And I also advise, although I know it's at the judge's discretion, that it's probably unlikely that you, Your Honor, would sentence them to a jail time.
Well, actually, I wouldn't sentence at all. It would be before a different judge, and I don't think that there's any mystery to that. It probably would be probation.
Yes,
But I certainly I can't make representations about that to the degree.
Oh, I didn't realize.
I'm sorry, let me I just need to say this. Notwithstanding what I just said, I certainly cannot make representations with certainty with regards to any sentencing, as we don't really practice with Cobb's pleas anymore. I can't make any guarantees about sentencing, particularly because I won't be the sentencing judge. It would be another judge that has jurisdiction over misdemeanors.
Yes, Your Honor. And if I may, I didn't want to imply that I was promising my client that that's what you would do. I was just telling my client, in my 30 years experience of practicing down here with these particular charges, in my experience, it would, in my opinion, would be extremely unlikely. It would probably be a period of probation, fines, and costs. And there's no points as far as I'm concerned, and I'm kind of baffled, Your Honor, that my client is.
Given the offer that is on the table, Mr. Torbert, do you want an opportunity to think about it? Because I certainly appreciate what you're saying, that you're learning of this right now, and you just want to make sure you're proceeding in a way that is best for your interests.
Yes.
I get that. So what I'm asking you,
I'm sorry for interrupting,
No,
Your
go ahead.
Honor. He just didn't learn of it just now.
Oh.
I discussed this in detail with him
I see.
yesterday.
I see.
And so this idea that I just sprung this on him now, that's false.
And I appreciate the fullness of the record there in that regard. Would you like an opportunity either to go into the hallway right now and speak with your attorney about it a little bit more, or to set this over sometime next week? And the offer, I'm sure Mr. Prosecutor would still leave it open.
As long as we can set it for PCC.
Okay, I just want to have some more time to talk to him.
I have no problem with that. It is a big decision. I don't mean to, your concerns are not falling on deaf ears. So I don't want to rush you. I don't want you to feel as though your arm is being twisted. If you're going to.
Before a judge or before a jury, because these are misdemeanors.
Can you please mute your microphone, Mr. Simon? Thank you. If you're going to make a decision based on what's been presented, I want you to feel comfortable with it. I don't want you to have questions that you feel are unanswered. And what I'm going to do is bring, what day can you come back? Do you want to come back next week or in 2 weeks?
Your Honor, if I may, since this is going to be a PCC and my client's not in custody, would this be via Zoom? Because that would make a difference.
I would be comfortable with Zoom, and I would imagine if it is going to be a PCC, that the prosecution wouldn't have an objection.
Of course not, Your Honor.
Okay. The distinction, I think maybe I should explain this one step further. We're throwing around PCCs. The distinction between a PCC and exam date is that the officers will not be here on the date that we return. So if counsel, if your client changes his mind and says, well, I want to reject this offer, then I need everybody to zoom in on whatever date we pick here to make that indication on the record, and then we would have to set it for another in-person exam. Do you understand?
Yes.
So you're not giving up any rights today. I'm just giving more time for you to speak with counsel and appreciate the offer, whether it's good for you, bad for you, and make a decision based on what you learn.
Okay.
Okay? Yeah. Mr. Counsel, what day do you want to come back?
Your Honor, may I just put a few things on the record first? So regarding this plea, in general, I do have a habit of informing the defense at the first PCC. I don't know if that happened in this case because it's very frequent people stand in. I did call the defense earlier this week, so it's not as though there was necessarily a tremendous amount of time between when I contacted the defense about this plea and now. I do want to just state, though, that in my experience, the court and the defense's earlier statement that these cases generally are given probation plus fines and costs is consistent with my experience. I tend to follow the cases after they go through sentencing. That's consistent with what I've observed. If the court is inclined to adjourn this. I would object to an adjournment. My officers are here today. We're ready to proceed with the exam. This case was scheduled.
Wait, I'm sorry. Are you objecting to adjourning for a PCC? I thought you just said you didn't object to that.
Your Honor, if the court is inclined to adjourn it, I would ask that we schedule this as a PCC, but I was.
Oh, I'm sorry. I thought we were all on the same page. Yes, it's not going to be an exam. It's going to be a PCC. Do you have an objection to that? I thought we talked about the offer remaining open. No?
I'll acquiesce, Your Honor. At some point we have to get through today, I'll acquiesce.
If I may, Your Honor.
I don't want to twist your arm either, Mr. Prosecutor. If you don't want to leave this offer open, then you have to definitively tell me. I thought everybody was kind of moving towards the same direction of allowing Mr. Tobert, and he's unsure. He's unsure, and I get that. This is a big deal. It may not be, you know.
I certainly appreciate that, Your Honor. If there is a way we could resolve this today, that would certainly be desirable.
Okay, we're gonna get a new date. A new date for PCC for which the officers will not need to be here because it won't be an exam date. And if you want to take advantage of the offer, which the offer's been placed on the record, it seems like it's reasonable. Yes?
Oh, Your Honor, I'm sorry. I apologize, Judge. It's a long morning.
Okay,
Confusing morning. I was going to say, Your Honor, I am going to speak to my client since we're both here in person extensively in the hallway.
Okay.
If in the event today, this morning, he changes his mind, could we resolve it today?
Absolutely.
Even though we get a new date.
Just
If we don't come back, yeah, obviously, we'll just keep the PCC.
I've got an open door.
That's all I was trying to ask.
Yeah, I'll speak to my client since he's here.
Yes.
And if we can resolve this today, fine. If not, a PCC date.
I think that's an excellent suggestion. So, new PCC date is going to be the 30th of July via Zoom at 8:30. If you walk in the hallway and have an ample opportunity to discuss this matter and want to take advantage of the offer, I'm here for that too. I'm back in this morning.
Understood, Judge, and thank you, you and your staff. And if I don't come back, I'll see you on the 30th.
Okay, sounds good.
Thank you, Your Honor.
I'm gonna call these. Mr. Schwartz, did you need a breakout room with Mr. Ristenbad, or can I just call the case?
You actually, you know what? Why don't you give me a breakout room, please, for a couple moments? Thank you.
Okay. Here is, can you ask Ms. Bailey to come in here, please?
Yes, ma'am.
I've got Mr. Simon up here. I'm gonna call this Cody Hawk case. I'm not sure what's going on, but calling parties on Hawk, case number 2056300. The people of the state of Michigan versus Cody William Hawk. The defendant is charged with count 1, prisons, prisoner possessed contraband. Count 2, controlled substance possession, analogs, habitual offender, 4th offense notice. Judge, this is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Bren Bailey on behalf of the people, P84009.
Good morning, Simon, P3556 on behalf of Mr. Hawk, who is in the custody of the Michigan Department of Corrections.
Thank you. Is he present? I don't see him.
He's not.
Oh, are you requesting to waive his presence?
Well, Judge, apparently the people are not ready to proceed, so, yeah.
Okay. Based on what I'm thinking is going to happen, I have no problem with his presence being waived here today. Counsel, what are we doing?
Your Honor, I'm asking for an adjournment. On June 28th, I was informed that the only witness that I had for this exam was going to this entire week. I did email the court as well as Mr. Simon, letting them know, asking to go back on the record for an adjournment. And I additionally made the request again on the 14th. So, Your Honor, I believe that there's good cause. My witness will be back on Monday.
Okay. And I see that this was supposed to be an in-person examination. Was this information playing a role in why he's going to be he was zooming in today?
Judge, that's why I'm not there. I do thank the people for giving me advance notice that it was not going to happen. This will either be a dismissal or an adjournment, and therefore I took the opportunity to Zoom.
Thank you. Okay, and what I was really asking also was that, is that why the defendant is not physically here? Or is he here?
Your Honor, I didn't have any indication that he was in MDOC.
Oh, so therein lies another problem.
And I'm usually very good about writing that down. So as such as that I didn't know he was in MDOC, I did not do a writ for today.
Okay. All right, well, it sounds like the first issue, there's a couple issues then, and the first one that was presented was that the officer is on furlough, and I appreciate the fact that you made not just one, but 2 attempts to notify not only the court, but Mr. Simon about this issue, so everyone had a heads up. That being said, I am going to grant an adjournment. How many days do you need to effectuate a writ and transport?
2 weeks.
Okay, so today is the 16th.
Yes, ma'am.
Mr. Simon, what does the week of August 2nd look like, or August 9th? We're spilling over here, but you know, he's in custody, so we'll make sure we get it in.
Well, for the record, I'd like to move to dismiss. This is about 1 or 2 year old allegation. Mr. Hawk is in the custody of the Department of Corrections, receiving absolutely for all this time. And I believe that this is good cause. However,
Mr. Simon, your audio is dipping in and out, so we missed a couple of words there, and that's a problem for Madam Court Reporter and myself, so that we can fully understand. Can you repeat what you said?
Yes, Mr. Hawk is in the custody of the Department of Corrections, receiving no credit for any of this time on a warrant, which I think is more than a year old and was held unforgivably for this long period of time until he was about to be released. And then suddenly it pops up and detains him. I think that under the circumstances, I would move to dismiss without prejudice.
I certainly welcome you to file a motion in that regard. If you think that, you know, that would be appropriate and you'd like to do that, and Madam Prosecutor would have an opportunity to respond. But at this juncture, without that, we're going to proceed with setting an in-person examination. I do find good cause to grant the adjournment. And what date would you like to set this for?
I'm sorry, what were those available weeks again, Your Honor?
Well, we don't have available weeks, but keeping in mind that he's in custody, we'll try and make a way either the week of August 2nd or the week of August 9th, because Madam Prosecutor said she needs at least 10 days to effectuate a writ.
I could do it the 3rd or the 12th, the 10th.
Judge, the 10th at 11 a.m.
The 10th at
The
August
10th at 11, yeah, that would work.
August at 11 a.m. in-person examination. Anything
you.
further?
Not at this time. Thank you, Your Honor.
Thank you.
Calling parties on Ristenbat, case number 2155326. People of the state versus Cruz Wyatt Gordon Ristenbat. The defendant is charged with count 1, assault with intent to murder, count 2, home invasion, 1st degree, count 3, assault with intent to do great bodily harm less than murder or by strangulation, count 4, assault with a dangerous weapon, felonious assault, count 5, assault with a dangerous weapon, felonious assault, count 6, malicious destruction of building, $200 or more but less than $1,000. Habitual offender, second offense notice. This is scheduled for a competency hearing.
Thank you. Appearances, please.
Dick Bloomers, on behalf of the people.
Good morning, Your Honor. Stephen Schwartz on behalf of Mr. Ristenbat.
Mr. Ristenbat, state your name, please, sir.
Cruz Ristenbat.
Yeah. Okay, do we have a report back?
Yes, Your Honor.
And?
Your Honor, the report suggests that my client is competent to stand trial, as well as the fact that the criminal responsibility came back the same way, that he's competent as far as assisting I'll leave it at that if that's good with the court, and we would stipulate to that report.
Prosecution?
The people would stipulate as well.
The court finds based on those stipulations and the evaluation done by the forensic center that the defendant is competent to stand trial. What's your pleasure, counsel?
Your Honor, if it's okay with the prosecutor's office, at this point, we would waive the preliminary exam.
Mr. Bloomer?
I can't accept a waiver at this time because this is a capital case. If it's something they're serious about, I can talk to my supervisor, but our policy is a whole thing that's a capital case. So right now I can't take that.
Your Honor, with that being stated, why don't we schedule this in 2 to 3 weeks for another PCC and then get to the bottom of whether or not we could waive the exam.
Okay, how's August 6th at 8:30 via Zoom?
Your Honor, could we do it the week after? I may be out of town on that date.
August, well, you pick a date, pick a date.
Sure. How about August 11th?
Let's do it, August 11th
Sure.
at 8:30 via Zoom.
Sure.
And that will give Mr. Bloomers an opportunity, if that's how you wish, you're still holding to wanting to wait, Mr. Bloomers will have an opportunity to run it by his supervisors. But if his response is still what it is today, that we'll address all of that when we reconvene on August 11th.
Sounds great. Thanks, everybody.
Thank you, Judge.
Anything further?
Nothing from the people.
Nothing from the defense.
Judge, you have the Robinson file. I don't know if there's anything else quick we can do this if we need to go to this.
Yes, if you could bring Robinson out. Why do I have the Hensley file? Did we do that?
I thought we did that already.
Oh, no, we passed on it for a moment. Okay, calling People versus Tyrese Robinson. This is 2105. Oh, counsel, did you need us? Yes.
With a decision real quick here.
It's a yes or no?
It's a plea.
Okay, Mr. Slosky?
He's coming.
Okay, before you go.
Oh, you got it. Wow. I'll just wait.
Thank you. Mr. Winters, good morning to you, sir.
Good morning, Your Honor.
Good to see you.
Always good to be seen and not viewed.
I feel like we heard from your client,
Yes.
on Zoom.
Yes.
Did he make his way?
I can get the equal. Mr. Slusky's here.
Okay, all right. Mr. Slusky, are you ready for me to recall Torbert?
Yes, Your Honor.
All right.
Yes,
This is a recall of People versus Jalen Torbert, Torbert. This is 2006223801. This case was already formally called. Can I have appearances again, please?
Good morning, Your Honor. Jacob Slusky on behalf of the people, P83677.
And I apologize, Judge. Excuse me 1 second. Thank you. Good morning again, Judge. Gerald Ferry, P44630, on behalf of Jalen Tolbert, who's present and physically present in the court. You state your name, sir?
Jalen Tolbert.
Good morning. Okay, counsel.
Your Honor, I've had an additional opportunity to speak to my client in detail concerning this matter. Also, that the generous offer that the prosecutor made. I also informed my client verbally of his rights, including his explanation as to the exam. However, at this time, he's waiving his exam, waiving his other rights, and he wishes to enter a plea of guilty pursuant to the prosecutor's offer.
Thank you. And Mr. Slusky, would you like to put the fullness of that offer on the record?
Yes, Your Honor. So currently, Mr. Torbert is charged with 4 counts of license plate DMCA 257.256. The people are willing to reduce that to a misdemeanor of unlawful use of a license plate 57. I may have misstated. License plate forgery is 257.257. We're reducing that to a misdemeanor of unlawful use of a license plate, which is 257.256, in addition to 1 count of no ops on person, which I apologize, let me just pull up the MCL for that. Which is 257.311. They're both 90-day misdemeanors. Additionally, the sentence in this case will be at the discretion of the sentencing judge, and diversion or delayed sentencing is not available.
Okay. Counsel, does that coincide with your understanding of the offer?
Yes, Your Honor, that's a fair and accurate statement as to the plea offer.
Mr. Tobert, do you understand the offer?
Yes.
Okay. So I just need to ask you a few questions before the plea is placed on the record. Do you understand, sir, that you have a right to?
Your Honor, if I may just stop you.
Yes.
Did you want to put him under oath?
Yes, I do, but not right now.
Oh, okay, I apologize, Judge. Every judge does it differently.
Oh, okay, no, I'm asking, no, yes, I do want to have him sworn in, but that's right before he puts on the factual basis.
Okay, sorry, Judge.
Okay, that's okay.
I didn't mean to interrupt.
Do you understand, sir, that you have a right to an attorney? And if you couldn't afford one would be appointed to you? I need an audible answer.
Yeah.
Okay, do you understand the allegations against you?
Yes.
Do you understand that you have a right to a trial?
Yes.
Do you understand that if a trial did occur, that the prosecutor would be presenting witnesses, that you would have an opportunity with your attorney to cross-examine?
Yes.
And you could even have witnesses subpoenaed and have witnesses testify on your behalf if you wanted to?
Yes.
Do you understand that if you tender a plea of guilty pursuant to this negotiation here, that has the effect of giving up your right to a trial? You understand that?
Yes.
So if you tender a plea here today and it's accepted, you can't come back in 6 months and say, I want to have a trial. I want the officer to come in, I want the people to come in and present their case. You understand that?
Yes.
Do you understand, or let me ask you this, has anyone promised you anything other than this negotiation to get you to give up your right to a trial? Can you unfold your arms, please, sir? Has anyone promised you anything other than the negotiation, which is that you plead to 2 misdemeanors and the felonies would get dismissed? Has anyone promised you anything other than this negotiation to get you to give up your right to a trial?
No.
Has anyone threatened you in any way to get you to give up your right to a trial?
No.
Are you pleading guilty because you are guilty?
Yes, I'm pleading guilty because I was operating a vehicle.
But this is real simple. Are you pleading guilty because you are guilty, or are you pleading guilty for some other reason?
I'm guilty.
Okay. Can you unfold your arms? I'm sorry. So here's just a few more questions, sir. I promise I'll make this as quick as I can. Do you understand that if I accept your plea here today, that I would not be the sentencing judge?
Yes.
This matter would go before Judge Bryant. You would be assigned a sentencing date that would be roughly sometime late August. And in the meantime, you would have an appointment with the probation department where they would interview you for a pre-sentence investigation.
Yes.
And that's an appointment that you're gonna have to make sure you make. I'm not certain if they're virtual. I'm assuming they still are virtual. You understand that?
Yes.
And based on the representation, the answers you give at that interview, a written recommendation would be prepared that you would have an opportunity to read, as well as your attorney, on the date of sentencing. Do you understand that?
Yes.
And prior to the sentencing occurring, you would have an opportunity to make any corrections or clarify anything that seems unclear, or even to highlight things that you felt were not highlighted in the report. Do you understand that?
Yes.
And also, do you understand that the sentencing judge will have discretion to sentence you as she deems appropriate? You understand that?
Yes.
So for instance, if something comes out in that pre-sentence report that leads her to want to add some sort of counseling or to impose a fine or cost, she will have the discretion to do that, even though we're not discussing it right here.
Yes.
Okay. And do you understand that if you're placed on some level of probation, that in the event you fail to abide by whatever terms are set forth at sentencing, that the court can then impose further consequences?
Yeah.
And lastly, as I believe, I don't have a copy of it. I will need a copy of it, Mr. Slesky, the plea offer. But from what I recall, Mr. Slesky saying, you have a copy, a hard copy?
Not on me physically, I did just type it up and I emailed it to Amy.
Oh, okay, all right. We're gonna print it out, put it in the file. One thing I do recall Mr. Slesky saying is that at the conclusion of whatever sentencing or period of probation, that this is not going to be dismissed.
Could you repeat that one time?
He indicated that there is no diversion that is available. And what I take that to mean is that this is not a matter that you would be placed on probation for whatever period of time, if it's probation, that the sentencing judge deems is appropriate. At the conclusion of that, even if you've done everything you were supposed to do, it's not then going to be dismissed. It would just be closed out. You understand that?
You saying it be closed out, so you saying like the matter of what I'm planning to reduce charges just be closed up?
Yeah.
It won't make me a third habitual and like, for me taking the plea to this, well then, like on my jacket, would it be like, oh, he a third habitual?
Did you want to answer?
If I may, Your Honor, and I discussed this at least a couple of times. Sir, you're pleading to misdemeanors. Therefore, any kind of subsequent, it will not affect a habitual offender under, as far as a habitual felony offender. Since these are misdemeanors, it would have absolutely no effect on that.
Okay.
Okay, all right. So with that being said, please raise your right hand. Oh, do you have any questions for me?
No, I don't have any questions.
Okay, please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yeah.
Thank you. Mr. Slesky?
Thank you, Your Honor, for the factual basis. Mr. Torbert, were you driving a vehicle in Wayne County, Detroit on December 2nd, 2020?
Yes.
And did the vehicle display a license plate? Was there a license plate displayed on the vehicle that you were driving?
Yes, it was a wrong one, I guess.
Did you
Can you speak up, please? Keep your voice up.
Yes, it was the officer discovered a paper plate in the back that wasn't valid.
Did you get that plate from the Secretary of State?
No, I never purchased the plate, I was just operating good.
Thank you, the people are satisfied with the factual basis.
Counsel?
Just briefly, sir, you admit to the fact that the plate was invalid, is that correct?
Yes,
Okay.
I witnessed that. The plate was
And at that same date and time in question, while you operated that vehicle, your license was suspended, is that correct?
Yes.
Okay, I'm satisfied.
Thank you. Okay, the court is likewise satisfied that your plea is knowingly and voluntarily given. As I indicated, you will have a sentencing date in late August. It will be August 27th before Judge Bryant at 9 a.m. And due to the plea to counts 1 and 2, the misdemeanors, the felonies are now dismissed. Mr. Slesky, I'd like your signature on this dismissal as it relates to the felonies.
Of course, Your Honor. Just to double check, you said 8/17?
Pardon?
The sentencing date, August 17th?
August 27th.
27th.
Okay, we're all set, sir.
Thank you, Judge. Sir, if you want to step out in the hall, I can talk to you and give you a quick explanation.
Thank you, Your Honor.
Thank you, Judge, for your patience and everyone, your staff, everyone. Thank you.
We're back on the record in the matter of People versus Robinson. I don't know that I fully called it, but it's People versus Tyrese Robinson, 2105796. The defendant is charged with count 1, homicide, murder, second degree. Count 2, weapons, firearms, possession by felon. Count 3, weapons, carrying concealed. Count 4, weapons, felony firearm. Count 5, weapons, felony firearm. I'm sorry, Madam Court, if I didn't put the case number on the record, it's 210579946. Can I have appearances, please?
Good morning, Judge Leslie Cooper on behalf of the people, P30857.
Good morning.
Good morning, Luther Glenn, P38683, appearing on behalf of Mr. Robinson.
And good morning to you, Mr. Glenn. Sir, could you please state your name?
Irish lawyer Robinson.
Thank you. And good morning to you as well. We are here to pick up on the examination that commenced on July 9th. Oh, I'm sorry, actually it started on June 15th. And we were here on July 9th. I have had an opportunity in the interim to, Tammy, can I hand this back to you? I'm handing back for the record Madam Prosecutor's digital discovery that I did have an opportunity to review. So let us pick up where we left off.
Judge, I would move for admission of that exhibit. I believe that would be 4.
Counsel?
Yeah,
I think we already, wait, People's Exhibit, that's, you have it marked as 4?
I'm marking it right now, Judge.
Okay, I have it as admitted, but did you want to speak to that? If you want to revisit it?
I have it admitted as 4 too.
Oh, well, in that case, I don't worry about it. Thank you.
Okay, all right. So with that being said, do the people rest at this time, or were there any further witnesses?
We were recalling Sergeant Reed.
Exhibit number 4 was the register of actions of prior conviction.
Oh, yes. So this would be 5.
This would be 5.
All right.
Okay, but then you have the Miranda rights was 2. So I figured that the video was probably 3.
In that case, whatever the correct number is, just if it's 3, then we'll do 3. I have to look at my notes.
Okay, I don't see that I admitted number 3. So is there any objection? Pardon?
I was just saying it was probably going to be marked as 3.
Oh, I see. So is there any objection to people's proposed 3?
For example, the zone, no, yeah.
That will be admitted, the digital discovery will be admitted as People's Exhibit number 3.
Thank you, Judge. We were going to recall Sergeant Reed to the stand. He was testifying before we broke for the technology.
Okay. Good morning. Could you please state your name for the record and also spell your first and last name before you sit down?
Yes, ma'am. Okay. Sergeant Javaris, Javaris, Reed, REED.
Thank you. Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, sir. Once he is situated, Madam Prosecutor, you may continue.
Thank
you.
Yes, ma'am.
Okay, so speak clearly so we can hear you, okay?
Yes.
All right. So before we broke to admit the video of this situation, we were discussing the fact that you in fact were present for that interrogation. Is that correct?
Yes.
Okay. And you heard obviously the answers that the defendant gave to any questions that were put to him. Is that correct?
Yes.
Okay. During the course of your investigation, was the marijuana that was allegedly at the root of this transaction ever recovered?
No.
Okay. There was discussion from the defendant that he obtained, excuse me, a weapon from the decedent. Is that correct?
Repeat that question, sorry.
The defendant claimed that he retrieved a weapon from the person he shot.
Yes.
And was that weapon ever recovered?
No.
In fact, what did he tell you about what happened to that weapon?
Yes.
What did he tell you about that?
He stated that he sold the weapon.
Okay. And did he tell you how much he received for it?
No.
Okay. I don't think I have any further questions, and I'll pass for cross.
Thank you. Cross-examination, please.
Good morning, Sergeant Reed.
How you doing, sir?
I'm great. I just have a couple of questions here. Firstly, during the interrogation, the other detective who was in the interrogation, what was his name?
Sergeant Gnatic.
Can you spell his last name?
Gnatek.
Okay. And are you the officer in charge of this matter?
Yes.
During the time of the interrogation, was Sergeant Gnatic the OIC? I said during the interrogation of Mr. Robinson, were you still the OIC at that time?
Yes.
Okay, all right.
Mr. Glenn, can I interrupt for one moment?
Yes.
I just want to indicate, I should have at the beginning of this, that sequestration is continuing. I have enabled the waiting room and I have put everyone who is not an attorney into a waiting room, and I've clamped down on that. But I do want to stress that if there's anyone watching the live proceedings of this matter on YouTube, if you are a witness or a potential witness, it would be inappropriate for you to watch these proceedings. You should stop from watching the proceedings given the sequestration order to maintain the integrity of this process, as it may preclude you from testifying in the future. I apologize for the interruption. Mr. Glenn, please proceed.
Now, during the interrogation of Mr. Robinson, there was mention of some surveillance videos from neighborhood homes. Do you remember that?
Yes.
All right. And I believe it was Officer Gnatic who made that statement. I mean, Sergeant Gnatic.
Yes.
Right. Now, was that statement true?
No.
So as of this date, there are no video surveillance of this incident at all?
We canvassed that block, but we could not find any surveillance video.
Okay, let me rephrase it. None that you discovered or collected?
Yes.
All right. So there's a fair statement to say when there was reference to seeing my client motioning or acting during this period, during this incident, those statements were not true?
Yes.
Okay. Now, with respect to a weapon, during the interrogation, there was mention that there were no shell casings of a separate gun or a different gun other than the one that allegedly Mr. Robinson had. Is that correct? Is that true?
Yes.
Eyewitnesses. Were any eyewitnesses to this incident that were interrogated or questioned by the police?
Initially, we had a neighbor that said they saw a vehicle pull up, but they didn't actually see, and heard shots, but didn't actually see anything.
Now, the neighbor that said they saw a car pull up, did they make mention of who was in the car, describe who was in the car?
They couldn't. They were down the street. They were farther down the street.
All right. So to your information, knowledge, and belief, there were no race gestile eyewitnesses to this incident?
No.
That you're aware of?
Yeah.
That's all I got. Thank you.
Any redirect?
No, Judge, thank you.
Okay, thank you. Sergeant Reed, you may step down from the witness stand. Are there any further witnesses for the prosecution?
None, Judge, thank you.
Mr. Glenn?
No witnesses, Your Honor.
Thank you. Is there a motion?
Yes, Judge, I will move, and I have already spoken to defense counsel about this. I'm going to move to actually amend count 1 from homicide murder in the second degree to a felony murder charge. I believe the facts on this record are abundantly clear that this was an underlying marijuana transaction that went very bad, and that in the process, the marijuana disappeared, but also the defendant has admitted during the interrogation that he took the gun took a gun from the decedent and sold it for profit. So I would ask, I think that there is sufficient probable cause to believe that this charge should be increased to felony murder. The remaining charges, of course, as charged, and I would move to find those over, Judge. Thank you.
Mr. Glenn?
Well, Your Honor, in this matter,
I'm sorry, just please, Mr. Glenn.
Oh, sure.
Use the microphone.
Your Honor, in this matter, during the interrogation of Mr. Robinson, I thought it was pretty apparent that the detectives who were interrogating Mr. Robinson did not believe that that the deceit was armed. And to me, when I was looking at the tape, that was quite apparent. And they kind of were questioning Mr. Robinson as to whether or not he was telling the truth with respect to the decedent possessing a firearm and my client actually taking it. And so I would object to the charges being raised for felony murder, because during interrogation, the only reason why this wasn't charged as felony murder at the beginning was because they didn't believe the guy had a gun, and so nothing was taken. So I'm thinking, to come here now and to say that, well, all right, your client made these statements, even though we don't believe them, we're going to amend the charges here. And I think that's grossly unfair. The prosecutor made the decision at the charging time that unless something else comes up, there was no gun that was taken. We don't know what happened during the alleged confrontation between my client and the decedent. And so without more about whether or not there was really a gun or whether there was really marijuana or any of that, all you have is the intent or the general intent of the homicide, because there's nothing else here that anyone, I think, has any merit or credibility that it was a felony murder, that something was stolen or taken. I understand the prosecutor's argument here, but I'm saying, well, no, you're making an argument, a legal argument, but I think that is the argument that they themselves didn't take that position when they charged my client. They charged my client with second-degree murder because they didn't believe it. And I'll leave that at that.
Can I respond?
Yes, please.
First of all, charging decisions are not on this record. I didn't make the charging decision, and I don't know who did, but whoever did, they did it for whatever reason. But the facts that come out at exam are what we are talking about now. Speculation is irrelevant, and speculation about what officers did or did not believe is not on this record in any way, shape, or form. So I understand that counsel may have a belief about that, but we have no facts to support that. The facts that we do have are the facts that came out from the witness stand and from the interrogation of the defendant, where he admitted what he did, which was to steal a weapon and sell it. So I think that, we have sufficient probable cause. Who knows what would happen at a trial, but certainly for this proceeding, based on the record and in the words that we have from the defendant himself, as well as the investigating officers, that's it. So I think we have more than enough to bind over on the increased charge of felony murder.
Thank you.
Thank you.
Okay, I've had an opportunity to not only listen to the testimony that we began with on July 9th, but also to, June 15th, I stand corrected. And continue on July 9th and finish up with today, coupled with the exhibits that were admitted, particularly that last exhibit that I had an opportunity to view between the last court date and today, which was the interrogation of the defendant. This is a probable cause hearing, and the burden on the prosecutor, Mr. Robinson, is to establish by a probable cause standard only that crimes were committed in the city of Detroit, county of Wayne, and that you probably committed those crimes. It's a low burden. It's a much lower burden than is required across the street. And I always like to emphasize that so that you have an understanding of what this process is about today and what determination I need to make as it relates to what's been presented before this court. And based on the information, it's kind of hard to unhear. It's hard to unring the bell once the bell has been rung. And given the testimony that is on this record, including the exhibits, again, that digital discovery, which I did review, the interrogation, the court does find that there is sufficient evidence that has been presented to bind over on all matters, including the increased charge, count 1, felony murder. I would expect that a first amended would be provided to Mr. Glenn. And that we do need the MCL number though, for purposes on our end here, if you could provide that to the court.
Sure.
And, the arraignment on information date is going to be the 23rd of July, July 23rd at 9 a.m., wherein Mr. Robinson, the burden of proof rises significantly to beyond a reasonable doubt. And Mr. Glenn, I'm confident that he will hold the prosecution to that much higher standard that is required at that higher level. But at this stage, the prosecution has cleared the hurdle of probable cause. Is there anything further in this matter, Madam Prosecutor or Mr. Glenn?
No.
No, you're not.
Thank you. Okay. Oh, I gave the exhibit back, the disc?
I do have it.
Okay. And I don't believe I have any other, I think I handed the ROA back.
Everything else I have.
Okay, all right, thank you.
Thanks. Is it all right if I call you with that?
Yeah, absolutely. You can call Madam Clerk or email it to her.
I have to have it today though. I'm off next week and I have to have it. I don't know if you can do it, Joe.
Oh, yeah, let me bring them back in.
Your email address is.
I got your Jones.
John.
Which one?
Yeah, that will, just
All right, thank you.
Madam Clerk, I just texted APA Bloomers to see if he could come back so we could get an exam date.
Okay.
I just don't want to get stuck behind another exam if possible. Sorry to interrupt.
No worries.
No, that's okay. We're trying
Thank
to.
you.
Mr. Konecki, good morning to you, sir.
Morning, Your Honor. I'm scheduled for a 10:30 in person, but I haven't had much contact with my client. So did Mr. Vasquez Espino check in?
Officer?
That would be a negative.
That's a negative according to the officer.
Let me go check.
Thank you. He's gonna check the hallway though. Mr. Bloomers, there was someone looking, oh, Ms. Murphy looking for you.
Yeah, we're ready to go back on the record.
Okay.
And then can we see who's in Wayne County Division 1? What's your name, sir?
That's a negative, Your Honor.
Here, Glenn.
Mr. Konecki, that person's not here.
Okay, I'll call it real quick.
Is that Derek Graham, Judge? If it is, that's my case with Mr. Quinn. I didn't hear what he said.
Yes.
It is Mr. Let me get this one down. What do you want me to call?
Mr.
Vasquez?
Oh, Vasquez and Henley are both mine, so.
Okay. Calling parties on Vasquez Espino, case number 2157367. The people of the state of Michigan versus Antonio Joshua Vasquez Espino. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, domestic violence. This is scheduled for hearing. Yeah, yeah, I'm gonna put it posted on it.
Okay, appearances, please.
Jacob Bloomers on behalf of the people.
May it please the court, Neighborhood Defender Service of Detroit by Jeffrey Konecki on behalf of Mr. Vasquez Espino. Your Honor, he has not appeared this morning and I have no further information I can provide the court.
Okay. Was this set for an exam?
Yes, Your Honor, it was set for 10:30 for preliminary exam.
All right. Have we received a phone call from that individual?
No, no calls received.
Today being the date and time set for an examination at 10:30, it's currently 10:43, and the defendant has failed to appear, which is unfortunate. Mr. Prosecutor, did you have witnesses here?
Your Honor, the complaining witness, Christina Vasquez, also failed to appear this morning. Espino was set for her appearance.
Okay, well, the first thing is that Mr. Vasquez Espino needs to be here. His failure to appear here is problematic. Is there a motion?
Your Honor, the people move for habeas.
CAFEUS is going to issue, keep in mind, Mr. Konecki, that the CAFEUS will be entered sometime around 2:30 or 3. So in the event you're able to have your client even Zoom in, I would allow you to make the appropriate motion, given the fact that a witness has failed to show. But if it's anything after 2:30 or 3, he will have to avail himself in the ordinary fashion of anyone that has an open warrant.
Understood, Your Honor. I'll make my best efforts, but I'll be before Your Honor again at 1:30 this afternoon for the continuation of another exam.
Oh, okay, fantastic. So the previous bond is revoked. And, oh, he's on a tether. He's on a tether, so maybe we can get him here real easy.
That would be fantastic, Your Honor.
Well, it won't be today, but again, I just state one more time, if you can reach him and even Zoom in, even though he's supposed to be here in person, if you can Zoom him in, I will allow you to make the appropriate motion since no witnesses have shown up. But short of that, he will, because he's on a tether, he's probably gonna be picked up.
Understood, Your Honor.
Previous bond is revoked. New bond is going to be set at $20,000 cash or surety with a GPS tether.
Thank you, Your Honor. I'll see you at 1:30.
Yes.
Mr. Quinn, are you available for Mr. Graham?
I saw Attorney Quinn just a short while ago. I may be driving though. I thought I saw him in a vehicle.
Oh, yes. Recalling People versus Hendley, Hendley. First name is Latia, 210-58245. This case was already formally called. Can I have appearances again, please?
Jacob Bloomers on behalf of the people.
Kathy Murphy, P51422 for Ms. Hendley, who is present.
Ms. Hendley, please state your name again.
You're on mute, Ms. Hendley.
Henley, Latia Michelle Henley.
Thank you. What's your pleasure?
Your Honor, we would like an in-person exam date, please.
Okay, are there any concerns, Mr. regarding bond?
No concerns at this time, Your Honor, and I did have a chance to speak with the complaining witness in a breakout room this morning.
Okay.
Judge, October 15th at 10 a.m.
That'll be fine. Your Honor, Ms. May I address a couple of issues?
Absolutely.
Ms. Henley still has not had an opportunity to retrieve belongings from the home that they shared. I know that we're never going to get a civil standby from DPD. Would the court authorize a third party to go to the home to retrieve items that belong to her children? If such person has a list of things that belong to Ms. Hendley's children?
Well, I'm just assuming, I'm going to assume that there's already been a conversation between yourself and Mr. Bloomers about this, no?
We did discuss it briefly. It was after I talked to the complaining witness, but I do see him shaking his head no.
Your Honor, he can't unlawfully keep belongings that are not his.
Well, here's the thing. I'm hoping that perhaps there can be someone that both the prosecution and the defense are agreeable with to enter the home and retrieve whatever belongings, so long as those belongings are not in question as to who they actually belong to. If, as you indicated, if there's a list that can be provided to Mr. Bloomers, and if there's, and Mr. Bloomers can speak with his witness about, and then there's, if there is a third party then I'm fine with it, but that's gonna take a little bit of legwork from the prosecution and the defense putting their heads together to hash that out. Like, think about it. Zoom
we
back
can
in,
do that.
because we've got quite a bit of a docket here we need to get to.
We can do that, Your Honor. And I would just like to place on the record that Mr. Smith has been calling Ms. Hendley. Ms. Hendley has not been answering the phone. So if you could direct Mr. Smith to stop contacting Ms. Hendley, Your Honor, I would appreciate it.
Mr. Smith? So, can you hear me? Can you hear me?
Hello?
Yes, can you hear me, sir?
Yes.
Okay, so I just want both parties to hear this. There is a no contact provision that is in place. What that means is that the defendant cannot contact the victim, yourself, Mr. Smith, not directly or indirectly. That would include letters, telephone, chat, text, any form of social media outreach, or even having someone else act on her behalf to reach out to Mr. Smith. It's really important. If that bond is violated, the bond certainly can be absolutely revoked. It's very serious. Now, while the bond is on Ms. Hendley, I always encourage the prosecutors to speak with their respective witnesses to inform them that they should not be doing anything to reach out to the defendant in an effort to either gaslight them or even to talk about things that are pleasant. And, there is no contact that should be had either way. But Ms. Hendley is the one who's got a bond that could be revoked if you engage. And even if Mr. Smith comes to your doorstep, you are not then permitted to engage with him.
Your Honor, Ms. Hendley fully understands that. That's why she has not been answering the phone. However,
Okay.
I wanted.
And I understand that, but I just want to be clear that I do not have a bond on Mr. Smith, so there's no court order that can be imposed. But I am going to encourage you to listen to the prosecutor, who I'm assuming has already told you, Mr. Smith, you should not be reaching out to the defendant. Do you have questions on that, sir?
I haven't, and she violated her bond a couple of days after she got out of jail.
I thought Mr. Bloomer's represented that there were no issues.
Well, we did speak about it. He mentioned this. This did happen quite a while ago, and we talked about it, and the resolution was that unless there were any further issues, since this was, this is the second PCC, this came up way back, as he said, a couple of days after she was arraigned. Hasn't been any contact since then, according to him, and so I was not going to move for a revocation of bond at this time. I said if there's anything, I gave him my number, I said if there's anything further that happens at this point, since it's been months now without any further issues, then he should contact me directly and then we can do something about it.
Mr. Smith, you should not be contacting her either.
I haven't.
Okay, please make sure that you continue to just separate yourself at this time while this case is pending. That's going to be really helpful to this process. And is there anything further?
No, Your Honor, thank you.
Yeah, Ms. Murphy and I will be in contact about the possibility of that property transfer.
Okay, all right, sounds good. Thank you so much for your patience.
Thank you. Ms. Hendley, I'll call you.
Okay.
Gotta throw that bit under the jail.
Oh my goodness, is Sanders gonna be adjournment?
Well, if we can approach the bench, for a minute.
Yes. Okay. Mitchell is zooming in though. Yeah, Mitchell's gonna zoom in.
Ms. Mitchell, are you with us?
Yes, I am, Judge. Good morning.
Good morning. As soon as the court reporter returns, we're going to call it.
Okay.
Who are we waiting on for the
Mr. Quinn, and then, there's one more jailer too.
Mr. Quinn?
I'm here.
All right, I'll call that too. I don't know if he needs a breakout room.
So do you need a breakout room with your client, sir, Mr. Quinn?
No, I'm going to go visit them after next week.
Okay.
Tammy, did anyone check in on Morris? I think it's NGS, but I don't know who it is.
It's Mr. Bicker. He's up there, it's just, I can't call it until they gotta move one guy out to knock someone else in, so.
Bounced out.
He was there top of the morning, but I didn't have the attorney, so we switched it around.
I feel like we're losing valuable court time.
I know.
Is it just me?
We got too much to
Is
get.
Cantonary ready?
We're ready, Your Honor.
Let's do it.
Well, we're gonna wait for protocol.
Oh,
Yeah, that's what we're waiting on. I got all kinds of stuff I can call right now, I just need for the recorder to come back.
how are you doing, Mr. Harris?
I'm doing fine, Judge. How are you?
Good, thank you. Good to see you. Are there witnesses on Cantonary?
Yes, ma'am. How many?
2. Witnesses on Collins?
2 icons out there.
Yes?
Yes, ma'am. I have everyone I need on both of those cases, as well as the Johnson case as well.
Hey there.
Thank you, Judge.
You're welcome. Mr. Quinn, Judge. Calling parties on Graham.
Hold on one second, Tammy.
Oh, I'm sorry.
Okay, go ahead, thanks.
Case number 21-58852, the people of the state of Michigan versus Derek Keith Graham. The defendant is charged with count 1 and 2, criminal sexual conduct, first degree weapon use, SORA notice, HIV, STD testing notice. Count 3, unlawful imprisonment, SORA notice. Count 4, unlawful imprisonment, SORA notice. Count 5, 6, 7, and 8, robbery armed. Count 9, assault with a dangerous weapon, felonious assault, habitual offender, fourth offense notice. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Good afternoon. Good morning, Judge. Nida Simone, Assistant Prosecutor for the People, P45356. There is a count 10 as well. I don't know if Madam Clerk did she say it and I missed it? There's a felonious assault that's count 9 and 10. Not that it matters, but I just wanted to make sure that we're all on the same page.
Well, it does matter. We're talking about Graham.
Correct.
It's not on there. I have count 9 is my, I thought you said, how many counts do you see?
10. Well, me, Judge?
Okay, I see count 9 is the felonious with a knife, and then the habitual offender notification.
All right, I'm gonna have to follow. I didn't have this case before. A different prosecutor had it, and there was another count that was added. So I think you have the old felony information, and I apologize. We'll get that to you. There is a total of 10 counts on this with the habitual fourth, Judge.
Duly noted. Today being a PC. I'm sorry, Mr. Quinn, did you put your appearance on yet?
Oh.
Is it Quinn's case?
You're muted, Mr. Quinn.
Christopher Quinn, P69483, appearing on behalf of Mr. Graham, who's also appearing via video conference.
Thank you. Mr. Graham, please state your name, sir.
Derek Graham.
Thank you. Today's the date and time set for PCC. This is actually an adjourned PCC. What's your pleasure, counsel?
I have received the discovery link from the prosecutor. I'd like to set it for an in-person examination.
Okay. Would you like to select a date then? First week in August?
If I can check my schedule.
Sure.
Judge, I am before you on another exam, August 3rd. If we could do it that day, then we have 2 exams back to back. You might get tired of me, but I'll be there.
We probably have like 14 exams back to back, but that's okay.
I have James Curtis live exam before you on the 3rd of August. Sorry, Mr. Quinn.
This would be in the afternoon, Judge.
I would like it to be, but we're jammed up. We've got homicides every afternoon from here to like the end of August.
Okay.
How many witnesses do they have?
How many proposed witnesses?
2 for the people, Judge.
Hold on one second, Judge. What are the other dates available, Judge?
There are no dates, but since your client is in custody, we're gonna elbow out other matters. So you tell us what day you can come and we'll.
I could do the 3rd. The afternoon would be better. I do have a federal hearing at 11:30. So if they want to start, if we can start at 9 or maybe 1 or 1:30.
We're gonna have a homicide in the afternoon that's already preset. So, well, can you be here at 9:30, Madam Prosecutor?
I can be. I'm on the 3rd. I'm already there for another matter. The only thing is Mr. Quinn said he had to be somewhere at 11:30.
Yes.
Well,
I can be there at 9:30, Judge. Do you want to, are we going to bump out Curtis then?
Oh, is it in custody or not?
Not in custody.
I mean, honestly, we have like, I wasn't exaggerating when I said we have like 14 exams already, so.
I believe that. Well, we can pick another date. I just.
Yeah, I don't have a problem. Well, what is the next date available?
Every single day looks like that up through the end of the year. So like the judge said, if it's in custody, that will take preference over out of custody cases. So we can schedule it for the 3rd at 9:30.
Let's do that. In-person exam. August 3rd at 9:30. Please pack your patience on that date though.
Well, is the Curtis exam going to still stay as it is? The other exam that's scheduled, Judge, that's not in custody, or is somebody going to let us know? I just want to know to tell my victim.
Everything stays on the docket.
Okay. All right. That's fine.
See what we can get through.
I got you. All right. Very good.
All right. Okay, we're all set. Thank you so much.
Judge, I have one other thing. I got an exam in front of you on the 23rd in person, Antoine Robinson. And I just found out my son, his team is going to the state Little League championship in Norway, Michigan. And that's
Congratulations.
Yes, thank you.
Is it a in custody or not in custody matter?
I believe he's Mr. Robinson is out of custody. It's a stalking case. I can send a request. I don't know how the court wants to handle it.
We need the corresponding prosecutor, and then once you have that person, and you can just zoom in and we'll adjourn it.
Okay, sounds good.
If you could just make sure we have enough time in advance that the prosecution can call off their witnesses, that'd be great.
Okay, I'll get in contact with the prosecutor. Thank you.
And congratulations to your son.
Yeah.
Okay. Thank you. Yeah, all right.
Thank you, everybody. See you August 3rd, Judge. Thank you very much.
Call this Sanders case real quick. Calling parties on Sanders. Case number 2156322. The people of the state of Michigan versus defendant number 1, Leo Sanders. The defendant is charged with count 1, larceny, $1,000 or more, but less than $20,000. Count 2, stolen property, receiving and concealing $1,000 or more, but less than $20,000. Habitual offender, second offense notice. Defendant number 2, Leon Sanders, is charged with count 1, larceny, $1,000 but less than $20,000. Third or subsequent offense notice. Count 2, stolen property, receiving and concealing $1,000 or more, but less than $20,000. This matter is scheduled for preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Jacob Slusky on behalf of the people, P83677.
Morning, Your Honor. William Winters, P35975 on behalf of defendant number 1, Leo Sanders.
Ms. Mitchell?
Unmute, Ms. Mitchell.
I'm sorry. May it please this most honorable court, Rena Mitchell appearing on behalf of Mr. Leon Sanders, who's the second defendant.
Mr. Leo Sanders, please state your name.
Yes, Leo Sanders.
Leon Sanders, please state your name.
You say Leon? Leon.
The second.
Leon.
Leon.
Leon Sanders.
Thank you. All right. We're here today for actual examination. What is the status of what we're doing here?
I'm sorry to interrupt, Mr. Slusky. To my knowledge, I think Ms. Mitchell has a motion to make before the court.
Yes, that's correct, Bill.
Okay.
Your Honor, I'd like to withdraw off of the case for Mr. Leon Sanders. There's been a breakdown in attorney-client communications.
Is that true, Mr. Leon Sanders?
No, it's not true. I would like another lawyer.
Okay, that's fine. Thank you.
That's what she's saying.
Yes.
You want another attorney?
Yes, ma'am.
Okay.
Thank you.
Ms. Mitchell, I am going to allow you to withdraw as counsel.
Thank you, Judge.
And we're going to call, we're making a phone call right now, Mr. Leon Sanders. Madam Clerk is speaking to the proper people right now to assign a new attorney. Now, that new attorney is probably not going to be in the hallway, but they will probably be zooming in just a moment. We're gonna see how quickly how quickly we can be accommodated here. But that does throw a little bit of a monkey wrench in terms of this examination, because I certainly wouldn't make an attorney who knows nothing about this case proceed to an examination today. And I don't think you want that. Why, you're pointing to Mr. Winters?
But he's on my case because he got my bulletins.
Right, right. That's what we're gonna, exactly what we're gonna talk about. So we're gonna wait in the hall right now until a counsel comes to talk to you personally. So thank you very much, Your Honor. We'll see you in just a few minutes when the case is called.
I think he's asking if you represent him.
We got the same case.
Well, yes, they're both innocent, but they're, potentially conflict. So later on,
Okay,
that's why you have two lawyers.
okay, all right. So
Thank you.
we're gonna call you back in just a moment when we get the new attorney.
Thank you.
Okay.
Thank you, Your Honor.
Is Mr. Baker on?
All right, thank you, Judge. I'm leaving.
Thank you, Ms. Mitchell. Have a good weekend.
All right, you guys too.
Calling parties on Cantonary.
We're gonna call you back in just a moment when we get the new attorney.
Case number 2057533, the people of the state of Michigan versus Anthony Joseph Cantoneri. The defendant is charged with count 1, home invasion, 2nd degree, count 2, breaking and entering, illegal entry without owner's permission, habitual offender, court defense notice. This is scheduled for preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Brand Bailey on behalf of the people, P84009.
Good morning, Your Honor. Wyatt Harris, P54891, on behalf of Mr. Anthony Cantoneri, who stands to my right. Your Honor, I'd like to
Please
make.
state your name, sir.
Anthony Cantoneri.
Thank you. I'm sorry, Mr. Harris.
I'm sorry, Your Honor. I'd like to make a quick record.
Okay.
I gave to Mr. Cantoneri, this case has been going on for some time, and I've emailed to Mr. Cantoneri his discovery in this particular matter. I also took it upon me to make a copy of his discovery in this matter, along with some other paperwork in another matter. And put that in a folder and gave it to Mr. Cantoneri this morning. Mr. Cantoneri holds on to that document for all of probably about 5 to 10 minutes at most, and took that document, folded it, and threw it in the trash. I indicated to Mr. Cantoneri, if you don't want it, you could have given it back to me so the rest of the world can't see your discovery. I was not about to go in that trash can, given the state of affairs of COVID and everything today, and retrieve those documents. I wanted to make that as a record, put it on the record, so if there's ever a question about discovery, I've got a record.
Okay, I certainly understand that. Okay, are we proceeding to an examination here today?
Your Honor, the people are prepared to proceed. However, I do wish to bring something to the court's attention. Mr. Cantoneri does have 2 other pending matters in the 36th District Court. Both of those other matters are scheduled in front of Judge Jefferson later this year. Judge Jefferson does have the oldest case. I discovered this a couple of days ago, and the file, my physical file, indicates that this was transferred, or should have been transferred back in November or December to Judge King and then subsequently to Judge Jefferson. Like I said, the people are prepared to proceed today. I just wanted to let the court know that there are 2 other pending matters for Mr. Cantoneri and that Judge Jefferson has the oldest case.
Well, it should have been transferred, sounds like, but I guess the frustrating part is that now that we're here, and I'm assuming, as I think you said off the record, you're ready to go. I would hate to adjourn this just to forward it to Judge Jefferson. What are you asking the court to do?
Your Honor, I'm not sure I'm really asking for anything. Essentially making the court aware.
Yes.
And if the court saw fit to move it.
I would have ordinarily, but, prior to the date of the examination where the defendant is here, I'm assuming the defense is ready to proceed as well as the prosecution. So unless there's some sort of meeting of the minds as it relates to a future date, I think it's appropriate to honor everyone's time to the extent that we continue forward with this examination.
Yes, Your Honor.
Okay. Any other preliminary issues or concerns?
Nothing for the people.
Mr. Harris,
Nothing from defense.
first witness.
Your Honor, at this time, the people would call Tom Finney to the stand.
Good morning. Ms. Sanford, are you here for spot appointment? Are you muted? Ms. Sanford, are you here for a spot appointment? She's not connected.
I'm
Okay,
connected
sir.
now. Can you hear me, Judge?
Yes, are you here for spot appointment?
I am.
I suppose you can't make your way down here. Would that be too much?
Yeah, that would be, and I would have to decline if that was the case. They told me it was just gonna be an adjournment.
No, I kind of kid, but kind of not. So how are we going to, is there any way we can call him back in here? And
Yes.
if you could just hold tight for just a moment, sir.
Just put one or all of them.
I'm not sure. They seem as though they work as a whole.
Yes, they're one person, I think. True twin.
Tammy, do I still have that file?
I think so. I don't think you gave it back to me because we didn't do anything with it.
Oh, yeah. Okay, this is People versus Leon Sanders, 210-563-2201. Mr. Slusky, your appearance, please.
Good morning, Your Honor. Jacob Slosky on behalf of the people, P83677.
Okay, Mr. Leon Sanders, please state your name.
Yes, my name is Leon Sanders.
Okay, so we have an attorney that has just dialed in. She is newly assigned to your matter.
Thank you.
Would you like to put your appearance on the record?
Attorney Monica Sanford, P62315, on behalf of Leon Sanders.
So I'd like to link the two of you up so that there can be some discussion about what's going on. And Mr. Slusky, I need him to have an opportunity to forward all of the information regarding this matter to you, which means that it looks like we're setting a new date for you to come back, Mr. Sanders, so that you'll have an opportunity to speak with your attorney, ask her any questions you have, and she will be glad to answer them, and you all can proceed together.
Your Honor, can I get a phone number today, please?
Absolutely. Can you, we're gonna write it down. What's your office number?
248-956-0119.
We're gonna set this for a PCC on, how about August 13th?
Your Honor, I'll be out of town from August 1st.
July 30th?
It'll be a busy day, but I'll be here.
Okay, how long are you on vacation?
2 weeks. 30th it works. 30th is good. Let's go with it.
Okay, July 30th at 8:30 via Zoom.
Farewell, Your Honor.
I will be with you, Judge. I got 2 other PCCs. I might be a few minutes late, but I will get you.
That's okay. So, seeing as though Mr. Leon Sanders' matter is going to be adjourned, co-defendant, I think we should address that. People versus Leo Sanders. No, actually separate case number. Oh, yeah, same case number. Sorry, 210-563-22. Mr. Winters, did you want to put your appearance on?
Yes, Your Honor. William Winters on behalf of Leo Sanders.
And Mr. Leo Sanders, please state your name, sir.
Yes, ma'am. Leo Sanders.
Thank you. All right, so for judicial economy, we're going to keep the case together. I will need you to zoom in on the date that we selected, July 30th, for a conference to determine what we're gonna do from there.
Yes, sir.
Okay, so your attorney will zoom in as well. Mr. Leon Sanders, I need you to zoom in on that date as well. And you'll have an opportunity to speak with your attorney in the meantime.
Yes, sir.
Okay,
Standing.
are there any other concerns we should address now?
No, Your Honor.
Nothing from me.
Thank you very much. Have a great weekend.
Are you okay, Mr. Sanders?
Yes, ma'am.
Oh.
Okay, thank you, ma'am.
Do you need a wheelchair, sir?
Yes, no, I'm okay.
Judge, Ms. Burton is just retained by Mr. Morris.
Can you please? Yeah, thank you. All right. I'm sorry, say again.
Ms. Burton was just retained on this Lawrence case. She's one in adjournment, but I know we've got to start on this and we're never gonna get done.
We're back on the record in the matter of people versus Catenary.
Water.
2057533. Can I have appearances again, please?
Good morning, Your Honor. Brent Bailey on behalf of the people. P84009.
Good morning, Your Honor. Wyatt Harris, P54891, on behalf of Anthony Catenary, who is in the courtroom standing to my right.
State your name. Okay, thank you. Let's pick up where we left off. Sir, could you please come forward to the podium? And can you state your full name and spell your first and last name for Madam Court Reporter here?
Thomas Joseph Finney Jr., THOMASFINNEY.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can come around this way. There's a little half gate that will open up towards you. Make sure you watch your step. Once you're settled in the witness chair, Madam Prosecutor, you may proceed.
Put a mask over your nose. Yeah, that one, pull it down towards your face. Oh, no.
This right here.
Oh, there we go.
There we go.
The microphone, I got
Thank
you.
you.
Okay.
Please proceed.
Thank you, Your Honor. Could you please restate your name for the record?
Thomas Joseph Finney Jr.
And Mr. Finney, what relation, if any, do you have to 600 Woodward?
That Vinton is a Bedrock property, is one of the company, or one of the buildings that Rock Security monitors.
So are you employed by Rock Security?
Yes,
Is that location of 600 Woodward here in the city of Detroit?
it is at 660 Woodward across the street in the Chase Building in Detroit.
Wayne County?
Yes, ma'am.
Were you at 600 Woodward on June 12th, 2019?
I was monitoring it via camera while I was at work, part of my job.
Were you monitoring it remotely or on
Yes.
site? Remotely?
Well, I was on site at my job, monitoring it remotely, so yes.
Okay, thank you. Did something happen at 600 Woodward on June 12th, 2019?
Yes, we received a door alarm from the roof, letting us know that somebody had accessed the building. So therefore, we immediately pulled up cameras and started monitoring the situation.
So.
Objection, no, never mind.
Well, let me just state, it's important for you to, even if you're working with a team of people, to confine your answers to the singular.
Copy.
Thank you.
So after you received the alarm for the roof, what if anything did you do?
I immediately pulled up cameras for that location and started monitoring to see what caused the door alarm.
And what if anything did you observe?
I observed a subject in the penthouse, which would be the mechanical room, where the door from the roof leads to.
And do you know how this person got to the penthouse mechanics room?
Yes, on camera review, the subject was observed in the alleyway behind the Vinton, which would be 600 Woodward, scaling a drain pipe to the second floor area where the fire escape was, accessed the fire escape, went up the fire escape to the roof of the Benton 600 Woodward, and then gained entry to the building.
And after reviewing this footage, what, if anything, did you do?
We immediately dispatched our secondary via radio, because we have a secondary deployment there, and also dispatched our on-site security officers to the site.
And after dispatching security officers, what happened next?
I was monitoring the video, the cameras live, observed the subject enter the stairwell, proceeded down the stairwell, walked through various floors, was observed trying door handles at the various apartments, ended up on, I believe, the second floor, because it's been a while now, and gained entry to an apartment on the second floor. And then we dispatched our DPD officers to that area with security. Then security and DPD arrived on site. Security is bringing up. I'm sorry. Okay.
No worries. So while observing the security cameras, were you able to get a clear view of the subject?
Yes.
Could you look around the courtroom and tell me if you see the subject in the courtroom today?
Subject's over there to my left.
Could you tell me something that he's wearing?
Right now?
Yes.
He's wearing a blue striped shirt.
Your Honor, may the record reflect that the witness has identified the defendant?
The record will reflect this.
So, after observing the defendant enter a unit, what, if anything, did you do?
Like I said, I called GP on the DPD officer on the radio, our secondary officer, notified him of the location, had security meet him at the door so he could get entrance to the building, and dispatch him to the location.
Your Honor, can I pause just a second? Is this gentleman that I'm pointing to here to the left, is he a witness in this case?
He's the officer in charge, and I had not intended on calling him.
Okay. And I'm sorry to point at you, sir. but
No, you're good. I apologize.
Please proceed.
Did you continue monitoring the surveillance cameras throughout the entire incident?
Yes.
And what, if anything, did you observe on those cameras after you notified the defendant, I'm sorry. What, if anything, happened after you made that notification that we just talked about?
So I continued monitoring on camera. So obviously I didn't have sight of the subject at the time because the person had gone into the apartment. DPD arrived on scene, entered the apartment, and detained the subject, left with the subject, took him outside where he was placed into custody and put into a police car.
Now, I'm going to object to an answer and move to strike. This witness testified that he did not see the subject after that, and so he's testifying to what somebody else did.
Your Honor, I'll ask for clarification, although I do believe the witness stated that he observed. Please clarify. So, Mr. Finney, could you see anything that was going on in the apartment?
No, I could not.
So, after everyone's exited the apartment, were you able to maintain visuals of everyone going down and out of the building as well as outside of the building?
Yes.
Then, Your Honor, I'm going to move to strike his previous answer about what took place inside that apartment, since he says that he did not maintain visual inside the apartment.
Your Honor, if I could just ask Mr. Harris for clarification as to what statement he's referring to of inside the apartment?
The witness said that he observed the police go inside the apartment. There are people, the police arrest the defendant inside the apartment. He can't testify to that because he didn't see it.
I don't believe that's what was testified to. I believe he testified that they went in and then came out with him and then detained and arrested outside of the building, which is what Mr. Finney could see.
That was his last answer. His answer before that, when I first objected, was what he said took place inside the apartment.
Well, the objection is sustained as to what took place inside the apartment. But I do recall that he indicated what he saw outside of the apartment, which was the defendant being detained and placed in handcuffs. But if there was testimony about what happened inside of the apartment for which the witness could not see, then I would sustain that objection.
Did the defendant have permission to be inside of the Vinton?
No,
Did he have permission to be inside of the apartment that he was located in?
no,
Did he have any keys?
no.
Was there anyone inside of that apartment at the time Mr. Cantoneri entered it?
No, there was not anybody inside the apartment at that time.
And how do you know that?
It was actually vacant at the time. There was actually being work done to it, so there was nobody living in that apartment.
Thank you. I have no further questions.
Cross-examination.
Well, Mr. Finney, you did not physically observe Mr. Cantoneri with your own eyes crawl up this piping system that you talked about earlier, correct?
It was on camera, sir, yes.
Okay, so my question is, you did not physically observe Mr. Cantoneri
No, I did not.
crawling up that pipe. You did not physically observe Mr. Cantoneri going inside the second floor, is that correct?
That is correct, sir.
You testified that this apartment was on the second floor, is that correct?
I said I don't really recall. I believe it was on the second floor, because it was a while ago, so I'm not really sure.
Okay, did you ever tell anybody that Mr. Cantoneri entered the second floor of an apartment?
Not to my knowledge, no.
Okay. Did you ever tell anybody that Mr. Cantoneri entered the ninth floor of an apartment?
No, I did not.
And you testified that there was no one in the apartment, is that correct?
That is correct.
Okay, and you only know that because they were doing maintenance on that apartment, is that correct?
That is correct.
And you never spoke to Mr. Cantoneri, is that correct?
That is correct, sir.
No further questions.
Redirect.
Just briefly, Your Honor. Mr. Finney, were these security cameras that you were reviewing live?
Yes.
And how many floors are in the Vinton?
12.
And
13 if you count the penthouse.
And which floor did you see him enter?
He entered through the penthouse, so that would have been the 13th floor.
And on which floor did you next see him?
12. Then, because he did continue down the stairwell, so.
Did you see him enter any rooms on 12?
No, he did not.
I have no further questions.
Mr. Harris?
No further questions.
Thank you, sir. You are free to exit the courtroom. Thank you so
Thank you
much.
very much.
Any further witnesses for the prosecution?
Yes, Your Honor. At this time, the people would call Officer Michael Roby.
Good morning.
Good morning.
Please state your full name and spell your first and last name for Madam Court Reporter.
My name is Michael Roby. My first name is spelled M-I-C-A-H. My last name is Roby, R-O-B-Y.
Thank you. Please raise your right hand. Do you solemnly swear or affirm testimony you're going to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. You make your way up here. The little half gate opens up towards you. And once you're settled, Madam Prosecutor, you may proceed.
Thank you, Your Honor.
argue about it, sorry.
All right, okay.
Please proceed.
Could you please restate your name?
Officer Michael Roby,
And I noticed you indicated that you were an officer. With which department are you an officer?
Detroit Police Department,
How long have you been employed with the Detroit Police Department?
almost 7 years.
Were you employed with Detroit Police Department on June 12th, 2019?
Yes, ma'am.
Did you in fact work on that date?
Yes,
Were you by yourself or with a partner?
by myself.
Did you have occasion to go to 600 Woodward?
Yes,
Is that here in the city of Detroit,
yes, ma'am.
county of Wayne?
Yes.
Why did you go there?
For a police run given to me by my employer at the time.
And what, if anything, did you do when you arrived at 600 Woodward?
I detained a gentleman who have been, who they said broke into a.
Objection to what someone said.
Objection sustained.
Did you enter 600 Woodward?
Yes, ma'am.
You mentioned that you detained someone. Where did you first come into contact with this person you detained?
Inside of the apartment.
Do you recall which floor that apartment was?
No, ma'am.
Would you have written such information in your report?
Yes,
Would your report refresh your recollection?
yes.
Your Honor, may the record reflect that I am approaching Mr. Harris to show him. Your Honor, permission to approach the witness?
Yes.
Thank you. So Officer Roby, what I'd like you to do is to silently review your report. And when you have finished, please look up at me, okay?
Yes, ma'am.
Thank you. All right. So can you turn it over in front of you? Thank you. Did that refresh your recollection?
Yes, ma'am.
Do you recall on which floor you encountered the suspect?
The 9th floor.
And was he inside of an apartment, outside of an apartment, or something else?
Inside the apartment.
And did you enter the apartment?
Yes, I did.
And after entering the apartment, what, if anything, did you observe?
I observed the gentleman inside with no shirt on, no shoes on, inside the apartment.
What were you observing this person doing?
At this time, he just came to the door and looked at me at this time. When I came inside, I don't know what he was in there doing prior to me entering.
Do you see this suspect in the courtroom today?
Yes, I do.
Could you please point to him and tell me something that he's wearing?
He's sitting over there. He's wearing a blue face mask and a black and white shirt with stripes.
Your Honor, may the record reflect that the witness has identified the defendant?
The record will so reflect.
After making contact with the defendant, what, if anything, did you do?
He was placed in handcuffs and taken to my squad car.
And then what?
Then I took him to Detroit Receiving Hospital
Why did you take him to the Detroit Receiving Hospital?
Because he made allegations that he wanted to harm himself.
Do you know if the defendant had permission to enter the apartment?
No,
No, you don't know, or no, he did not?
no, he did not have permission.
Objection, how would he know unless it was told to him?
I'll
That would be
withdraw.
hearsay.
Objection sustained.
Actually,
The answer was, well, I'm sorry, yes.
actually, Your Honor, no. Under Michigan Rule of Evidence 1108 B8, the people are allowed to enter hearsay as proof of possession or permission to enter or use.
But you've got to lay a foundation. You've got to lay a foundation. You can't simply ask this officer witness a question and then he just answer without a foundation.
I will lay the proper foundation, Your Honor.
Thank you.
While on scene, did you have occasion to speak with anyone involved in the management of 600 Woodward?
Yes, that was Rock Command, the company I was working for.
And without telling me exactly what was said, what was the nature of these discussions?
That the gentleman who was inside the apartment, he was not supposed to be in there.
Objection, Your Honor, that would be hearsay, was the nature.
I'll rephrase.
Sir, what's your name, Wayne County? Morris. Division 1. Please state your name. Please state your name, sir. State your name. What did you say that was? It's Mr. Baker's client. I didn't realize Mr. Upshaw had a case in here. I didn't either. Who's the prosecutor on Johnson?
It's 1108 B6.
Okay, with the district court.
Yes. Your Honor, I'll withdraw. No further questions.
Okay. Cross-examination.
No questions, Your Honor.
Thank you, officer. You may exit the courtroom. Thank you so much. Any further witnesses for the prosecution?
No, ma'am.
Mr. Harris, any witnesses?
No, Your Honor.
Motion.
Yes, Your Honor. At this time, the people move for bind over on all counts. Your Honor, we heard today from several witnesses. The first witness indicated that he observed.
Wait a second. You said several. I saw two. Am I?
No, that is two.
Two? Were there more than two?
No.
Oh, okay. Several makes me think there's more than two. Go ahead. I'm sorry. I just want to make sure I didn't miss a witness.
First, we heard from Mr. Finney, who is involved in the security of 600 Woodward, Your Honor. He indicated that while on duty, he observed live footage of Mr. Cantoneri entering the penthouse through the mechanics room after climbing up a drain pipe to gain access to the fire escape, Your Honor, and then continued down through the building, Your Honor. He did not have permission to enter through the rooftop facility into any of the suites present therein. He did not have a key. He did not live there. He did not have permission to be there, Your Honor. No one was there at the time. It is a dwelling. It is an apartment building, Your Honor. It was being renovated or updated for maintenance. And we also heard from Mr. Finney that he observed the defendant checking numerous doors, trying to open many, many doors as he continued throughout the building, Your Honor, until he found one that he could enter. And which he did enter without permission, Your Honor, therefore did break and enter into a building. Case law indicates that that some force must be used, Your Honor. The simple opening of a door does constitute as such force. Therefore, I believe that the people have met their burden. Mr. Hurst?
Your Honor, I'm going to object to count one, home invasion, and the second degree. While there is testimony that there was a breaking of this apartment, there was no testimony as to what took place in that apartment. No, and the prosecutor must show that there's either an intent to commit a larceny or an intent to commit some kind of assaultive offense. There is no evidence on this record. The first witness testified that he didn't see, could not observe what took place inside the apartment, and the second witness indicated that he arrested him and he did not see what was inside that apartment. What was going on inside that apartment? Nobody's testified to any kind of a larceny or any kind of a felony being committed inside that apartment. So I would ask the court to dismiss count one and no argument as to count two.
Your Honor, while it might be true that neither of the witnesses testified as to what exactly went on in that apartment, I think based on a probable cause standard, that by climbing a gutter, entering in through the roof, and checking numerous doors repeatedly until finding one that Mr. Cantoneri could get into, Your Honor, could indicate that he was looking for something. And I believe that with intent to commit a larceny, Your Honor, is a question of fact for the jury. We did hear that he entered an apartment on the 9th floor, but also entered through a roof access and into a suite on the 12th floor, Your Honor. Mr. Cantoneri was removed immediately from the apartment. No further investigation was, as far to my knowledge, or testified to here today, was done as to what happened on the interior of the apartment. However, I do believe that it would be a question of fact for the jury.
Okay, I agree that there's always, at the end of a preliminary examination, there's sufficient evidence, then it would be a question of fact as to certain details. But the one detail that's missing here is the second prong of that count one, which is entering without permission with intent to commit a larceny. And it's a small, it may be a small portion, but it really isn't. It's an aspect of the home invasion second degree. And there has to be, even at a probable cause hearing where the burden is much lower than across the street, there has to be some modicum of some indicia that is presented on the record as it relates to that element, that aspect of the charge. And there has been nothing placed on the record as it relates to the with intent to commit a larceny therein. As such, the matter is going to be dismissed as it relates to count 1, the felony, home invasion, 2nd degree. Count 2, the breaking and entering illegal entry without owner's permission, is going to be set for a pretrial before, would that be Judge Garrett?
Judge Bryant.
Judge Bryant.
It's a DV, it's Judge Bryant.
But this is not DV.
Yeah, Judge Bryant.
Oh, Judge Bryant does,
She
Judge
does
Garrett
jury.
does DVs, okay. What pretrial date can we assign?
Just do it for the 30th.
The 30th,
July 30th.
July 30th at 9 a.m.?
Yes.
Your Honor,
Yes, sir.
with that, I would ask the court to, if the court would kindly remove Mr. Cantonary's tether. May we approach, Your Honor?
Yes,
Hold on.
maybe over this way.
Mr.
Maybe this
Okay.
way.
Am I?
Yes, Ms. Bailey,
Okay.
yeah.
Just, I don't want to approach without.
Yeah, no, this is on this matter.
Thank you. Go
Given
ahead.
the testimony of today and circumstances in which this court heard this particular case, Cantonary is asking, and I'm asking this court, if they would remove Mr. Cantonary's tether.
Madam Prosecutor.
Your Honor, people would object, as I put on the record prior to the start and subsequent finish of this preliminary examination. I notified this court that the defendant, Mr. Cantonary, has 2 other felony criminal cases pending in another court, Your Honor. And I believe that the removal of a tether at this point would be completely improper, given that he does have other cases and matters pending.
Your Honor, it's my understanding that Mr. Cantonary has 1 matter in front of Judge Jefferson, not 2. And so I would ask the court to still consider my request.
Okay, is it 1 or 2 other matters?
He has,
I think it's just.
if I could have 2 seconds.
When I looked on Odyssey this morning, Your Honor, I saw.
Yeah, Your Honor, I've got the one that we just held, and then 19060958, and then 2105674101.
Nature of the allegations?
I am pulling that up as we speak. The 2021 file, Your Honor, trespass upon key facility, impersonating a peace officer to commit a crime. Those are the 2 charges on that one. And then the 2019 file, Your Honor. Is breaking and entering a building with intent, I apologize, as the only charge.
Thank you. I'm going to keep the tether on. I'm not going to remove the tether at this time. Not only is there the misdemeanor matter that's residual effect of this case here, but there's, it sounds like, some other pending matters, including felony, that the defendant still has that's outstanding. I'm going to keep it in place at this juncture. And again, the felony that was before the court. And this matter this morning has been dismissed. The misdemeanor remains with a pretrial date of July 30th at 9 a.m.
Thank you very much.
Thank you, sir.
With regards to an order from the court on a dismissal,
Yeah, I just filled it out. Yeah.
You mean just a few.
Okay, Mr. Upshaw, the name on your case?
Blaylock, Your Honor.
Okay.
Okay. Can you have Miss, Delphia Burton be ready to?
Do I have her?
No, I'm talking to the, officers to have Miss Burton come in. Miss Burton, can you have Miss Burton come in next? Calling parties on Blaylock, case number 2155421. The people of the state of Michigan versus Rashard Blaylock. The defendant is charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, assault or assault and battery. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Jacob Bloomers on behalf of the people.
Randall Upshaw on behalf of Mr. Blaylock, P number 43574.
Thank you. And Mr. Blaylock, please state your name.
Rashard Blaylock.
Thank you. Today is the date and time set for a preliminary examination. It was, what time was it set for?
11:30, Your Honor.
11:30. It's currently 11:56. Are we proceeding to an exam today?
Your Honor, at this time, the complaining witness, Alonzo King, is not present in the courthouse. He was subpoenaed to be here for that 11:30 time. Without his presence participation, people are unable to go forward.
Thank you. Is there a motion?
We're requesting a dismissal.
Okay. Given the time frame that it is right now and the time versus the time that this exam was set, prosecution has indicated they are not prepared to proceed. I'm going to grant that motion to dismiss. The matter is hereby dismissed without prejudice. It's really important that you understand, however, Mr. Blaylock, that while the case is dismissed, there's some trailer language after the word dismissal, and that is without prejudice. What that means is that it is possible that the prosecution can reissue on this case. If you have questions regarding the parameters of that, please make sure that you speak with Mr. Upshaw, and he will gladly explain it to you in further detail, okay? Do you have on a GPS tether that needs to be removed?
No, ma'am.
Okay. Mr. Upshaw, I just need your signature on this form that I'm filling out right now, and we'll be all set. Is there anything further?
No, Your Honor.
Calling parties on Barnes.
Oh, Tammy, yeah, on that last one, Mr. Harris.
All right. Calling parties on Barnes, case number 2061381. The people of the state of Michigan versus Pierre Barnes. The defendant is charged with count 1, controlled substance, delivery, manufacture, cocaine, heroin, or another narcotic less than 50 grams. Count 2, weapons, firearms, possession by felon. Count 3, weapons, ammunition, possession by felon. Count 4, weapons carried concealed. Count 5, 6, and 7, weapons, felony, firearm. Habitual offender, court defense notice, commission of a felony with a motor vehicle advisory. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, Your Honor. Bryn Bailey on behalf of the people, P84009.
Hey, yes, good morning, Your Honor. May it please the court, Delphia Burton appearing as new counsel for Mr. Barnes. Real name is Lamont Dudley.
Please state your name.
Pierre Barnes.
Thank you. All right, we're here today for an examination. Are we proceeding to same?
Your Honor, the people are prepared to proceed. However, after speaking with sister counsel, I don't believe that it would be proper for us to proceed to examination today. And I believe that an adjournment would be the best.
Wait, I'm sorry.
Your Honor, I'm coming in as new counsel. George Shedrow was his attorney. I'm coming in this morning. I spoke to Mr. Shedrow. He indicates that he had some medical issues and he wasn't going to be able to appear for this case anyway. So he went to the hospital. But Mr. Shedrow was on it, and then I'm coming in this morning.
I see. All right, certainly I understand that. And you understand what's going on here, sir?
Yes, ma'am.
You certainly wouldn't want Ms. Burton Harris, who's an excellent attorney, but even notwithstanding that, you wouldn't want her to proceed in a matter that she hasn't had a chance to properly review and meet with you about, right?
Yes, ma'am.
Okay, so the request here is to move this to another day. You understand that?
Yes, ma'am.
So with that being said, I do find good cause to grant that request to adjourn this matter to a date The defendant, it should reflect, is not in custody. So unfortunately, we cannot turn that date right around. Madam Clerk, what's the best we can do, October?
We can do October.
Is there an officers here?
I saw one.
Can you bring whomever you have into the hallway?
It just, it says Ms. Burton.
Oh, Burton, I'm sorry.
That's okay, Ms. Burton Harrison.
Yes, I'm sorry. And I said it twice too. Sorry. You understand how easy it is to make that mistake though.
It's been there, it meant often.
Okay, we have the officers present in this matter.
October 26th at 10:30.
You know what, maybe in a trial in, Washington, delivery cause of death. So that would probably be bad, those,
Okay, how about the 20th at 9:30?
no.
No?
Also a trial,
Alright.
another matter. Wait a minute. Let's see, I'm trying to go. So I have the time blocked off, can I get a different day? Because I got the time blocked off and I don't want to call and say that I am in trial.
The 29th,
That'll be.
October 29th at 9:30?
Now, officers on Barnes, are you on furlough at that time?
No, I will not be on furlough. Officer Campbell, no, I will not be on furlough.
Me either, no.
Okay, so October, again, what was that? 29th at 9:30. At 9:30. I only ask, officer, because this seems to be a recurring issue on exams that are reset, that it's interfering with furlough. I just didn't want that to be the case.
Did you say 9:30?
9:30. October, so sir, I need you here in the courtroom, just as you came today, on that date, okay?
That's the 29th
29th at 9:30.
October.
October.
Yes, ma'am.
Okay.
Your Honor, I do have another request. Mr. Shedrow, he did just email a copy of the paper discovery, but it's my understanding that there will be some webcam, and I'd like an in-car video as well.
Yes, ma'am. I will get you, all of the digital discovery, in a new link.
Okay, thank you so much.
Can we get, the parties on Collins?
Oh, yes.
Thank you, Your Honor. Good to
Thank
see
you. Thank you.
Have a good one. Can we get Mr. Rocker, his client? I don't know if anyone.
Still don't see Mr. Baker. Did he just?
I don't either,
Bail on
or
us?
Mr. Nienhaus. And actually, Miss Michon, Mr. Nienhaus's client called Miss Michon. Just because she had her on another case. And she didn't, her house was flooded and she didn't get down here today either. She forgot she had a court date, I guess, but. So
I thought you said Mr. Nienhaus.
Well, that's what he said. That's what I was told, so I don't know if it's both of them, but she was just gonna zoom in too.
Yeah,
As
I don't know
opposed to a
that.
KPN, so I don't know.
That's fine.
And then I don't know where Mr. Bicker's at. And I'm not sure who this is the wrong mess. I know he said it was gonna be a go. So they need to get in here.
Oh, this is holding.
I believe so, yes. Are they coming?
Yeah, they all the way up there.
Oh, they need to put a shuffle on it and get down here.
Mr. Nienhaus still needs to zoom in.
Yeah. And, all right. I'll see if I
Mr.
can,
Nighthawk is zooming in.
I'll see if I can find
Yeah,
it.
he's got flooding issues.
Mr. Nine.
He's gone. He left.
He left?
That's what, I don't know, I'm just reading the notes.
Who's the prosecutor on this? Oh,
Which one?
Morris? Is that yours, Mr. Bloomers?
Word, yes.
Calling parties on Morris. Case number 2159355. The people of the state of Michigan versus Will S. Morris. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, domestic violence, third offense notice. This is scheduled for a probable cause conference.
Thank you. Appearances, please.
Jacob, people.
So we don't have Mr. Bickert yet?
There he is again. Could you put your appearance on, sir?
I'm sorry, are you speaking to me, Your Honor?
Yes.
I'm sorry, Your
Yes.
Honor. May it please the court, Tyrone Bickert, appearing on behalf of the defendant. I apologize, it's a little hard to hear. I just stepped out.
Okay, today, I'm sorry, could you put your name on the record, Mr. Morris?
Will Morris.
Thank you. What's your pleasure, counsel?
Your Honor, I do not have discovery for Mr. Morris's case. I would ask either that the case be set for exam or for PCC, whichever is in the, whichever the court feels is necessary and more prudent. And then I would ask after we're done that I be able to do a breakout room with Mr. Morris.
Okay, well, I'm sorry, do you have discovery?
No, I do not.
Well, you tell me which one you want. Do you want a PCC in a week or do you want an exam date?
Your Honor, if the exam dates are where I anticipate them being, I would have no issue in the exam date. However, I'd hate to set an exam date and then an exam is unnecessary. So if the court wants to set it for PCC, I could review the discovery and determine whether it's necessary or not.
Your client is in custody though, so I
Correct.
would.
Right,
Right, so,
PCC, Your Honor.
okay, I was just saying that, yeah, okay. I mean,
Yes,
you know.
Your Honor was thinking faster than me. I apologize. Yes, you're correct.
All right. Okay, so a PCC is going to be on the 23rd, July 23rd, new PCC. Mr. Bloomers, can you make sure that Mr. Bickert gets the appropriate discovery?
Yes, Judge, and I did send a link to Mr. Bickert for the paper discovery about an hour ago, but I will follow up with digital in the meantime.
Okay, anything further?
May I just ask if there's any video that I should anticipate later?
I don't know at this time, but I will
Understood.
follow up.
I'll follow up with Mr. Bloomers. Thank you, Your Honor.
Okay, we'll see you at 8:00 on July 23rd.
Can someone put me in a breakout room, Mr. Morris?
Absolutely.
Thank you.
Okay.
Calling parties on Collins, case number 2056589. People of the state of Michigan versus Quincy Collins. The defendant is charged with count 1, weapons, firearms, discharge from vehicle. Count 2, assault with intent to do great bodily harm less than murder or by strangulation. Count 3 and 4, assault with a dangerous weapon, felonious assault. Count 5 and 6, weapons, felony, firearm. Count 7, weapons, felony, firearm. Commission of a felony with a motor vehicle advisory. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good morning, afternoon, Your Honor. Bryn Bailey on behalf of the people, P84009.
Neil Rock County, T number 48618. I'm counsel for Mr. Collins. Good afternoon, Your Honor.
Good afternoon. And state your name, please.
Quincy Collins.
Okay. Today is the date and time set for preliminary examination. We have 17 minutes before we have to shut the record down for lunch. I have no wiggle room with that per the union. So what is your pleasure? Are we proceeding, gonna try and start with maybe a few questions before are we proceeding?
Your Honor, the people are fully prepared to proceed with this prelim case today.
Confident, which I like. So it's always, if people aren't prepared to proceed, then it certainly raises a question about, how it is that the state could bring a case and not be ready to proceed. The challenge is here for us, we're ready to go as well. Here's the one wrinkle. There are 3 I don't want to give the court too much information about the case before you actually hear it, but there are 3 potential eyewitnesses who are related, one of whom is here, who is the complainant identified in the complaint. The other was someone who's been identified as his wife, who was in the front seat, who we had expected to be here. And the third is a man who was 83 years old, who was his uncle, I believe, who was in the back seat. My concerns are threefold. One, I had expected each of those witnesses to be here and to be able to fully cross-examine them at the preliminary examination. 2, if we start with, it's my understanding that his wife and the complainant's wife and his uncle are not present. I happen to overhear, I don't mean to say that I was eavesdropping, but I happen to overhear one of the officers ask the complainant if they were available or they weren't here. I certainly had expectations that they would be here as well, particularly when we're dealing with an 83-year-old. I don't want to forecast or give bad karma out there, but you know, he's an important witness for us. The third thing is that I'm concerned that if we start with anybody but police officers, that even though the court will issue a sequestration order, the complainant in this case is, I'll just say, intense. He is video demonstrably an intense person. And my concern is that because he was personally intense at the scene to the point of actually attacking Mr. Collins and had to be restrained, that a sequestration order, even if we start with him, may not actually be enforceable or may not actually have any merit. So I'm certainly ready to go whenever the court is. I would just like all 3 witnesses to be here and to cross-examine them in a row and to have them sequestered, particularly as it relates to Mr. James Roosevelt's subject, who, God bless him, he's 83, but I really had anticipated that he would be here.
Okay, so the 3 witnesses that you're referring to,
Your Honor,
I'm going to allow you an opportunity to respond. I just wanted to ask Mr. Rockheim just a couple of questions. I'm sorry.
That's okay. I just take all the oxygen out of the way.
So I just wanted to ask the 3 witnesses that you're referencing. They are the 3 complaining witnesses?
There's 1 complaining witness, and there were 2 eyewitnesses who were in the car with the complainant. Roosevelt subject, who was in the back seat, who was 83 years old. And I believe the complainant's wife, whose name is, I think it's Trainee Lilly.
Okay.
Trainee Lilly.
All right. Thank you.
So my concern is if we started with Mr. Lilly, I have no issue with that. I just don't know how the court would be able to enforce it. I know the court could order sequestration, and we would hope that everybody would honor that. But my observations of the conduct in the case of the scene suggest that is unlikely.
Okay.
To me.
So the other witness that you said that you're concerned does not appear to be here. I just want to say that the prosecutor certainly has within their discretion to bring forward whatever they feel they need to establish probable cause. And if there was some understanding that that witness would be here, which again, given the age that you've indicated that that witness is, perhaps it would have been prudent to preserve if that was something that the prosecution thought was necessary. But keep in mind, I know nothing about the case to the degree you do. And the prosecutor certainly is more intimate with the case and has the discretion to use whatever strategies she feels is appropriate to reach her threshold. Ms. Bailey.
But we have the right to call witnesses too. So
Oh, yeah, did you subpoena him?
I didn't, because I had anticipated that I didn't know that those witnesses would not be
I
here.
see.
I had expected that there would be an attempt to preserve the testimony of an 83-year-old, but like I said, I will.
Okay.
And I will do that. I have no issue with that.
Ms. Bailey, your response?
I would echo everything that the court said, that my strategy is, the people's strategy is people's strategy. And this case was scheduled for today's examination back in April. Absolutely no communications were had with myself inquiring as to who we were gonna subpoena or not subpoena. And I certainly, no one in my office made any promises that those 2 other witnesses would be here. Additionally, Your Honor, the complaining witness in this case is a retired officer. He told me while I was speaking with him that he worked with the FBI for 15 years. He's a retired officer, Your Honor. If the court orders sequestration, this witness will follow sequestration. The female passenger is no longer the complaining witness's wife. They have since divorced. And I don't believe that the concerns as to not following a sequestration are valid, as this complaining witness is intimately familiar with the system and would be able to maintain such an order.
Okay, well.
Yeah, that's a lot. I appreciate that the fact that he's an ex-police officer of some sort is meaningless to me. That doesn't tell me anything about whether or not, because I watched the video with multiple officers around where he acted anything like even a civilized person. I mean, I could call every officer in the hallway and come in here and would say that he acted like, demonic. So
Well, I don't want this to turn into,
I understand.
preliminarily talking, I don't want this to turn into a commentary on the complaining witness. But here's the issue now. This is the clock, according to my clock before me, is 12:18. So by the time we have a witness sitting in this chair, we're basically going to need to set a new date. Unfortunately, this is, you should understand, this is an ongoing problem as we try to accommodate as many examinations as we can in one day. Our priority are the custodial matters, which we've been hearing this morning, and as well as I believe we had some non-custodial matters as well. And it's really difficult trying to accommodate everyone, and certainly I don't want to dishonor your time or your attorney, Mr. Rothstein's time, which is extremely valuable. I know he's probably got 10 places he needs to be right now. And I don't want to dishonor your time as well, Madam Prosecutor, as well as your witnesses that have come here and were prepared. However, I have to deal with union issues in which I cannot tiptoe over 12:30. I know people don't understand that, but it's really straightforward. I'm just being, it's not difficult. I can't go beyond 12:30, and I have to pick up at 1:30 with another matter. So, we need to select a new date. The record should reflect that the defendant is not in custody. I say that to the extent that I cannot turn this exam around in a week or two, because again, we are struggling to accommodate the in-custody matters first. Ms. Bailey, were you gonna say something?
I would just ask that we get as soon as possible, Your Honor. This is the third time we've had to adjourn this matter for examination, and every time the complaining witness has been here.
But once it was adjourned because there was a concern about COVID, there was actually one of us that had been exposed, so there was an issue. It was adjourned before the actual.
Okay, yeah, according to my notes,
This is my first time
January
hearing it.
7th, unfortunately, the court was shut down, out of my control. The pandemic caused the court to close its doors. And on April 7th, I would like for the complaining witness to step in.
Judge, I don't have Mr. Subject's address. I will subpoena him the same date that we return for the exam.
Okay.
Unless I could ask the people to, since they probably have easier contact with him than I do, to make him available on that day.
Okay, thank you for coming in. I just wanted to make sure that you were aware of what's going on here. This matter was set for an examination today. It's 12:21, and we only have now 9 minutes before I need to shut the record down. And the reason I need to shut the record down is because the union mandates that court staff have an opportunity to go to the bathroom, get a drink of water, or perhaps get some sustenance. It is something that I don't have discretion with, and at 1:30, everyone needs to be back into the courtroom. They are required, the court is required to accommodate in that regard. So I know it does not make individuals happy. I know that you're ready. You want to handle your business. Mr. Rockhine's here ready to handle business. Ms. Bailey is here and ready. But the court cannot accommodate, as we've been handling in custody matters, which at the directive from the chief are our priorities to handle the people that are in jail. first. So with that being said, we are at a point where we're picking a new date, and I want to make sure that you're here to hear that new date and make sure it's not a conflict. It was mentioned that this is the third time this matter has been up for an examination, and I was just reviewing the record so that there doesn't appear to be any sort of inference that I'm just kicking the can down the road because I'm not willing to hear this. The first time that this matter was up for an examination, it had to be adjourned because the courthouse was shut down. Like the doors were locked. Because of the pandemic in January, the court was closed. April 7th, it was adjourned again for COVID concerns. And that brings us here today. And unfortunately, time is what's precluding us as we are dealing with the effects of the pandemic. Our dockets are busting at the seams. So as much as I would like to accommodate everybody and get everybody's exam heard, keep in mind also that in the event that this does proceed past this stage, and again, that's an if, I know Mr. Rockin, that's an if then, I don't know what will happen, but if it does proceed back to the next stage, there's a huge backup across the street. They haven't even started their jury trial, they start next week from the pandemic, the beginning of the pandemic. So just everyone else just needs to keep that in mind so that you understand the fullness of how the pandemic has affected the court system. That being said, Madam Clerk.
Should we do an afternoon?
Yes, because I don't want this to happen again.
The first afternoon we have available is September 2nd at 1:30.
September 2nd at 1:30. Mr. Lilly,
Yes, ma'am.
is that a date that works for you, sir?
Yes, ma'am.
No, Mr. Rockin, no.
Judge, I have an in-custody trial out of the area that starts on August 30th.
Okay.
So that whole week is out then?
Yes.
September 8th at 1:30?
That's fine.
Mr. Lilly?
September 8th, ma'am?
Yes, at 1:30?
Yes, ma'am.
Okay, in-person examination, and the benefit of setting this matter for the 1:30 time slot is so that nothing gets in the way. We'll start it, well, my expectation is everyone's here at 1:30 and we start. There will be no other cases on the docket at that time, but this one.
Judge, I've indicated to the court that it is our desire to issue a subpoena to Russell's subject.
Yes.
I wasn't provided his address in the discovery, it was redacted. Without having to go into all the people versus Jack issues about how those issues, addresses and like shouldn't be redacted. Certainly the people, I'm happy to give them a subpoena for his appearance. I'm happy to provide one for the court. I just don't have his address to send it to. I'm not asking to indicate his.
Madam Prosecutor, in the spirit of cooperation.
I don't believe the people have his address either. But I will provide, at least not in discovery, I'm looking, but I will provide an unredacted copy.
Thank you so much. I appreciate that. And again, September 8th at 1:30.
Okay, thank you very much.
Thank you. Good to
I
see
have
you,
just
Mr.
been
Rock.
informed by the OIC, who I believe was informed by the complaining witness, that all of them live in the same house.
Oh,
Okay, so I don't have Mr. Lilly's address either. That was also redacted.
Can that address be provided?
I'll have to talk with my supervisors, but I will get back with Mr. Rockin.
Okay, thank you. The court is going to stand in recess until 1:30.
Thank you.
Thank you.
Thank you.
Thank you.
Tammy, I'm assuming no, Mr. Nineheist?
1:30, just zoom back in at 1:30. He's not up there and we're down, so. that file? How do you lose a file?
Okay. Oh, which one? I have Blaylock.
No, the one for Johnson, for Mr. Nyan.
Yeah, no,
I haven't been anywhere. He's not on Zoom anyway, though, so they'll just have to Zoom back in and
Introducing Ms. Michelle.
No problem.
She was,
So typically, I would probably.
oh,
send
she was
emails
probably
out.
calling you from Miss Johnson.
Just kind of-
I don't know what it was.
But in this case, you know,
Not doing it. I must put it in a file or something.
All right, I tried to let her in, but she didn't.
Which way?
I'm gonna be down here for a few, Judge. I'll just tell them to Zoom in for 1:30.
So go with the force, or
I'll put
Is that how
a
it
little
goes?
chat
Yes.
in there.
not like from the other, not like from Handmaid's Tale, which is like under his eye, or,
Mr. Rockline, it's always a
Yeah.
pleasure to see you.
it's been so long, it seems like.
I know.
How are you? How are your boys?
Really good, doing well. I mean, you know, just still trying to navigate through the end of this pandemic as gracefully as we can.
But they're back.
Let me call you back.
She would have called me a
Yes.
little earlier then.
We're on our
All
lunch
right.
recess.
Yeah, this afternoon,
Hello?
because we're down for lunch, so I won't be able to see the judge, so. I will
Hi,
ask
Mr.
her
Clements.
to
Hi,
give
Miss
you a call back.
Michon.
Who's the prosecutor? Okay. Is she okay with it?
I don't think we can hear you though, if you all are talking to
Did
us.
she sign off on it? Okay, no problem, I see it. Okay, all right, I'll take care of it and I'll get it back to you.
Mr. Clements,
Okay, no problem.
can you zoom back in at 1:30? We can't hear you because you're muted.
I'm not on mute.
Oh, now you're not. We couldn't hear you before.
Okay. We were just trying to see if the court received our motion for our clients to be able to travel. But if not,
You guys are bombarding me. I just was on the phone with somebody about that. Here it is, Judge.
And, is this
They
general warrants
all
or?
signed off on it.
Oh, they did?
Yeah.
Okay, yeah, I'll sign it right now.
I don't see a spot for you to sign though.
Oh.
Let me see. Let me see if there's enough order. So here's what they're asking for, but it looks like the prosecutor and everyone signed off on it.
Okay,
I just need to print out.
Do you want me just to sign the bottom, or I don't know if there's?
well, yes, Judge, you would need to sign it, and then the clerk would have to send it to the jail because they won't accept it from myself or Mr. Royal.
Okay, there's no place for me to sign, so I'll just add it in there.
Okay, we apologize for that.
That's okay. Or it was there, but did we not print it out?
No, I don't see it. I don't
Okay.
see.
I'm just
either
gonna
one
throw it in here.
where there's anywhere. That's probably why I didn't give it to you. I just thought it was a motion.
Well, let me do this. I'm just gonna add some language on.
Okay.
What? I don't know if Miss Michon is having some technological problems.
She's on vacation, so I'm not sure why she's zooming in. I talked to her. I'll see if I can just give her a call. So I need to send this to this I.M. Smith at Wayne County.
Yes, please.
Okay, I'll take care of it. I'm sorry, I didn't see anything there was on here for the judge to sign, so I didn't know it was something you needed a signature on.
No problem. As long as we're getting it taken care of, that's all good. No problem.
Do it right now before I even go to lunch.
No, whenever you get it done, it's fine. Thank you. Have a good day.
You too. Take care. Okay. We had a matter. Oh, Mr. Connect.
Is he back in there?
No, Mr. His client is.
Oh.
Sir, he keeps people, I keep bringing them in and they bounce out. Well, Mr. Konecki calls and tell him 1:30.
Okay, I put a note in chat that we're down and we need to sign back on.
Sir? Sir?
Hi.
Hi, I need you to zoom back in at 1:30 and we'll call your case, okay?
1:30?
1:30.
Okay, ma'am. Thank you.
Don't forget, it's gonna be important.
Okay, I will. It just my phone wasn't working, and because of the weather and stuff. And then
I get it, but it's gonna be important to zoom back in. It'll be beneficial to you.
okay, I'm so sorry. Okay, 1:30 then.
1:30. Call your attorney too.
I've been calling him, but I've been texting him and calling him. He don't answer. Jeffrey, he don't answer.
Okay, we'll call him and make sure he's there too.
He's here at 1:30.
Oh, okay, good. Okay.
He will be in the court at 1:30.
Okay,
So-
thank you.
Don't forget to zoom back in, 1:30.
Okay, thank you, ma'am.
All right. So Tammy,
Hello.
Hello. The one that we, can you see, and then I sent an email to Mr. Bloomers.
Maybe Miss Bailey.
Miss Bailey, do you have a cell phone for Mr. Bloomers?
Yes, ma'am. Do you need me to get him on Zoom?
Yes, please.
Will do.
Thank you.
Yeah, so we're.
Can I pull that chair? Good afternoon, Your Honor.
Good afternoon, how are you?
And then we can, I'm gonna call his client back. I calls his client, she's on to Zoom, so
That's okay.
I'm gonna put her on speakerphone.
Okay.
She called me, so.
Okay.
Hi, this is Tammy. I'm gonna put you on speakerphone, okay? All right. Calling parties on Johnston?
Yes.
Case number 2061781. The people of the state of Michigan versus Angela Johnston. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Habitual offender, third offense notice. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good afternoon, Your Honor. Bryn Bailey on behalf of the people, P84009.
Good afternoon, Judge. Patrick 9 is P76343, and sorry I had to leave court today. Our whole basement started flooding, so I had to run home as fast as I could to install the sump pump.
I'm sorry to hear that. Okay, so, Miss Johnston, can you please state your name?
Angela Johnston.
Thank you. So today's the date and time set for preliminary examination. What is your request at this time?
Judge, I'm asking for an adjournment. It's my understanding that Miss Johnston's ceiling fell and she's dealing with flooding as well. So I'm asking for an adjournment, and the prosecution may object, but I'm asking to find good cause due to my basement flooding. And actually, I have notifications that most of Wayne County is flooding.
I'm not going to object, Your Honor. An adjournment, I think, would be a good thing, given the circumstances for everyone. So an adjournment is perfectly okay with the people.
Okay. Did you have witnesses?
Yes, ma'am, I did. I had the complaining witness today.
Okay, all right. Well, certainly given the representation that Mr. Defense Counsel's indicated with regards to the emergency circumstances he's dealing with, as well as his client, I give deference to both sides, whether it's a prosecutorial witness or the defense having an emergency or something that comes up, preventing one from getting down to the courthouse. So I do find good cause, again, to grant an adjournment request. That matter, the defendant is not in custody, so unfortunately we can't turn an exam date around very soon, but it will be probably in October.
Yeah, we can do October 26th at 10:30.
That works perfect, Judge. Thank you very much.
And thank you. And before we go, I would just like to let Mr. Nineheis and the court know that the people are going to be amending the charges to include a count of carjacking as well as a count of assault with intent to murder.
That's a lie.
Okay, Miss Johnson, don't worry about it. We'll take care of that later. Thank you for the information, Miss Bailey. I really appreciate it.
Yes, and I'll make sure that we get new information, and obviously if the preliminary examination does not support that, then we'll go from there.
Of
but
course.
That is currently the people's intent.
And I do have discovery already, Miss Bailey. But if you do have any further discovery based on the carjacking, et cetera, could you please forward that to me?
Yes, sir.
Thank you very much. And thank you so much for
You're
your
welcome.
indulgence, Judge.
You have a good day.
I appreciate it. You too. Thank you all very much.
Take care. Now, Mr. Vasquez Espino.
Okay, Hang up now. Good luck with your.
Yes, ma'am.
Hey, no, you know that was not
Your
funny.
attorney's gonna call you, okay?
I'm
can't
so
get in.
sorry. I'm sorry.
Okay?
I'm kind of,
Your
you had a
attorney will
live
get back
mic.
with you.
I
It's
was
in
just letting you know
October.
you had a live mic when you
Okay,
were
all right,
responding
all
to
right.
the previous
Bye.
case.
Do we have, is he not in the hallway?
He's not.
Oh.
And, Madam Clerk,
Yes.
I did reach out to Mr. Bloomers. He is currently driving. Is there
Okay.
something that his attention is needed for immediately, or might it be something that I might be able to stand in for him on?
I think it's something you could stand in on for him. It's Mr. Vasquez Espino's case where there were no witnesses. So as soon as Mr. Konecki walks into the courtroom, my intention is to call it. Mr. Vasquez Espino is currently on Zoom Gallery.
I'm not sure where he's at. While we're waiting, Judge, was this felony murder, was that an add-on count?
Yes, in exchange for count one. It was an amended count one.
So it's amended to the felony
Yes.
murder? Okay. I just need to know how to enter it.
Did she bring you the?
Yeah, she sent it to me, but I just want to make sure.
Had Mr. Konecki disappeared or have we not seen him at all yet?
I've been in contact with him. He said he was on his way up like 5 minutes ago, so I assume he's in the building.
Okay. Can you stand in for him when he comes in, Miss Bailey, or are you waiting to hear back?
I'm waiting to hear back what he says. I'm letting him know what's going on.
Okay.
He kind of was aware of it from this morning, but yeah.
Yeah,
No, I got you.
Hey.
Good afternoon, sir.
Good afternoon, Judge, and I'm hoping.
Yep, we have.
Oh, excellent.
Yeah.
Can you proceed on Mr. Bloomer's behalf?
Yes, ma'am. That was Mr. Bloomers, and he did ask me to stand in for him.
Thank you.
All right. Calling parties on Vasquez Espino, case number 2157367. The people of the state of Michigan versus Antonio Joshua Vasquez Espino. The defendant is charged with count 1, assault with intent to do great bodily harm less than murder or by strangulation. Count 2, domestic violence. This is scheduled for a preliminary exam.
Thank you. Appearances, please.
Good afternoon, Your Honor. Brent Bailey on behalf of the people, P84009, standing in on behalf of Mr. Jacob Bloomers.
May it please the court, Neighborhood Defender Service of Detroit, by Jeffrey Konecki, on behalf of the defendant, Your Honor.
Okay, and sir, could you please state your name?
Antonio Vasquez Espinoza Joshua.
Thank you. We are here today for, well, it was set for a 10:30 examination, and the defendant was not present at the time that the case was called. So a capias was issued, but it has not been entered yet. As I told both the prosecution and the defense that if Mr. Konecki was able to have his client at the very least Zoom in, that we would proceed with Mr. Konecki being able to make a motion for dismissal, as there was no witness that Mr. Bloomers represented that checked in. Ms. Bailey, did you confirm that there were no witnesses that checked in?
I did, Your Honor. The people did subpoena the complaining witness in this matter, Your Honor. And even now, she has not, or they have not appeared. So the people are unprepared to proceed today.
Is there a motion?
I'd make a motion to dismiss, Your Honor.
Okay, I will set aside the capias, even though it had not been formally entered. For the record, for the sake of the record, the capias is now set aside as the defendant has in good faith appeared here on Zoom gallery. And I am furthermore going to grant that motion to dismiss. The matter is hereby dismissed without prejudice for the reasons stated on the record. Mr. Konecki, I just need you to sign your name to this order of dismissal as the moving party. And lastly, does your client have on a GPS tether that needs to be removed?
I believe he does. Is that correct, sir? You're on a tether?
Yes.
So then we're gonna get an order for that to be removed.
Yes, I'm gonna add that language onto the order of dismissal. And we will notify the tether unit from our angle as well, but
Oh my
it's always,
God.
it's always good to have a copy of this, yes?
Yes. Yes, what was that?
Oh, I
Oh,
thought
wow.
What? Wait, I'm confused.
You said, what was the question, ma'am?
Did I ask the question was a few moments ago. It was about whether or not you had on a tether and your attorney
Yeah,
answered
I
for
said
you.
yes. I still got the tether on my leg. I can show you.
Okay.
That's okay, sir. We just wanted to make sure so that the order will reflect the tether is going to be removed.
Okay.
Okay, we are all set.
Okay, I am just now getting ready to process my work. We're calling another
Wow.
case. We got finished. I went to-
You're all set, sir.
Common cases. I'm getting-
Okay, that was it, ma'am?
Yes, sir.
That's it, sir. The case is dismissed and your tether can be removed. Once contact tether agent and tell them about this, they should know and they'll schedule you to come in.
Okay, okay, thank you. I appreciate it with your day and taking your time out the day to handle this. Thank you. I appreciate it.
Take care, sir.
Okay.
Thank you. You too.
Thanks.
All right, everyone, you have a good weekend and drive safe.
Two.
I'm afraid to go out the way everyone's talking. Calling parties on Arola Aguilar, case number 2158241. The people of the state of Michigan versus Luis Arola Aguilar. The defendant is charged with count 1, 2, and 3, assault with intent to murder. Count 4, 5, and 6, assault with intent to do great bodily harm less than murder or by strangulation. Count 7, weapons, firearms, discharge in or at a building causing injury. Count 8, weapons, dangerous weapon carrying with unlawful intent. Count 9, weapons carrying concealed. Counts 11, 12, 13, 14, 15, and 16, weapons, felony, firearm. Count 17, weapons, felony, firearm. This matter is scheduled for preliminary exam.
Thank you. Appearances, please.
Good afternoon, Your Honor. Keeper Cox for the people, E79915.
And may it please the court, Neighborhood Defender Service of Detroit, by Jeffrey Konecki on behalf of Mr. Areola Aguilar, C64800.
Thank you. Why don't we first start, before we pivot to the defendant, let's first start with the interpreter. Could you please state your full name and spell your first and last name for Madam Court Reporter?
Ricardo Cáceres, Caceres.
Thank you. Please raise your right hand. Do you solemnly swear or affirm to translate accurately, properly from English to Spanish, Spanish to English to the best of your ability?
I do.
Thank you, sir. Can you please state your name, defendant? Thank you. And we also have another interpreter. Let's put her name on the record first as well. Wait, no, before I forget, I do have a question. On this case here, I signed that for an interpreter, but I don't know, doesn't that need to go to the presiding? I mean, is that something I signed?
I'll look, because last time I think you signed it.
Okay, but I just don't want to do something that's improper.
Yeah, no, I'll double check.
Go to
But
someone
we did
else
this
to approve.
before, no, I'll double
Okay.
check it before I process it.
Could you please state your full name, spell your first and last name for the record?
Ines Ucros, Ines Ucros, Ucros.
Thank you. Please raise your right hand. Do you solemnly swear or affirm to translate accurately and properly from English to Spanish, Spanish back to English to the best of your ability? I do. Thank you, ma'am. Okay, are we ready to proceed to exam?
Yes, Your Honor.
Yes, sir.
Are there any preliminary matters?
I would just ask for a sequestration order for any witnesses within reception for my OIC who is in the building and said he would be stopping in, but he's on another matter. So if my OIC walks in, I would just ask for reception.
No objection to that.
Okay, the officer in charge will be permitted to remain in the courtroom. Let me also take a moment to say to the interpreters, if at any point in time we are moving too fast and you want us to slow down to allow an appropriate time for translation, please let us know.
Thank you, Your Honor.
Okay, thank you, ma'am. Thank you. Sequestration, the waiting room, that's where we were, sequestration. The waiting room has been enabled. So if there's anyone that you hear chime into the courtroom, it's because I've let them in and they're an attorney. Otherwise, I'm going to keep the Zoom gallery closed. The courtroom is already closed, if you will, as we are still maintaining the COVID restrictions that are in place, so there are no spectators in the courtroom. But the third tier to sequestration is that we are live streaming on YouTube. So if there's anyone watching the live stream that should not be watching it because you are either a witness or a potential witness, now is the time to stop from watching the proceedings, as it may preclude you from testifying in the future. Is there anything else that we need to address before the first witness is called?
No, Your Honor.
No, Your Honor.
First witness, please.
Thank you. At this time, the people will call Mr. Cesar Dela Cruz, and I will go grab him.
Okay, thank you. Could you please state your name, sir, your first and last name?
Por favor, diga su nombre, señor, su nombre y apellido.
César de la Cruz.
César de la Cruz.
Can you spell your first and last name?
Por favor, deletree su primer nombre y su apellido. Excuse me.
Please spell your first name and then spell your last name.
Por favor, deletree su primer nombre y deletree su apellido.
CESARDELACRUZ.
The spelling goes Cesar, C-E-S-A-R, space D-D-E, space L-A, space Cruz, C-R-U-Z.
Thank you. Please raise your right hand.
Por favor, levante su mano derecha. Derecha.
Do you solemnly swear or affirm the testimony you're going to give is the truth, the whole truth, and nothing but the truth?
¿Usted jura y afirma que el testimonio que usted va a dar el día de hoy es la verdad, toda la verdad y nada más que la verdad?
Sí.
Yes.
Thank you.
Gracias.
You come over here and
Por favor,
gate swings open towards you and have a seat in the witness chair.
por favor, párese, diríjase hacia el podio y se para en el estrado de los testigos. What?
Then will we have to adjust the microphone again like we did the other day?
Tiene que ajustar el micrófono como lo hicimos en la vez anterior. Gracias.
Yeah. May the microphone be next to the interpreter rather than the witness.
El micrófono tiene que estar dirigido hacia el intérprete en vez de que sea dirigido al testigo.
If you move that tissue box, it'll sit there. There we go. For you.
For me. Better?
Yes.
Okay, please proceed.
Por favor, proceda.
Thank you, Your Honor.
Gracias, su señoría.
And good afternoon, sir.
Buenas tardes para usted, señor.
If I may, I would like to take you back to May the 23rd of this year. Do you remember that day?
Bueno, si me lo permite, yo quiero que usted recuerde mayo 23 de este año. ¿Usted recuerda esa fecha?
Sí.
Yes.
And on that day, were you at a address of 2412 Anaroa Street?
Y usted en esa fecha se encontraba en la dirección de la calle 2412 Anna Road?
Sí.
Yes.
And is that location, the city of Detroit in Wayne County?
Y esto se encuentra en la ciudad de Detroit, en el condado de Wayne? Yes.
And is, at that address, is it a residence or a home?
Y en esta dirección, ¿esto es una residencia, una casa?
Sí.
Yes.
Do you know who lives there?
¿Usted sabe quién vive allí?
Sí.
Yes.
Who lives there?
¿Quién vive allí?
Mis suegros.
My in-laws.
Okay. And what are their names?
¿Y cuáles son los nombres de ellos?
David Hernández.
David Hernández
Juanita Guerrero.
and Juanita Guerrero.
Thank you.
Gracias.
May I have the spelling of those last names?
¿Puedo pedir que se letreen los apellidos?
Los apellidos nada más.
Only the last names?
Yes.
Sí.
H-E-R-D-E D-E-Z G-U-R-R-E-R-O.
The interpreter would like to make a correction, Your Honor. The interpreter is not understanding the spelling. If it is David Hernández,
How do you spell the names again, please?
vuelva por favor a deletrear los nombres. De David Hernández.
D-A-D-I-D.
Okay.
H-E-R-D-E-Z. If I may, Your Honor, I could question him and ask him. The spelling I have is the same spelling as he understands it.
Okay.
That's right. So, sir, you said your in-laws, one of them was David Hernandez, is that right?
Usted dijo que sus suegros, uno de ellos es David Hernández. ¿Es esto correcto?
Suegro, sí.
My father-in-law, yes.
Okay. And does he spell his last name H-E-R-N-A-N-D-E-Z?
Y él deletrea su apellido H-E-R-N-A-N-D-E-Z.
Sí.
Yes.
Okay, thank you.
Bueno, gracias.
Is that all right, madam?
Yeah, I just didn't know what it said.
Sure.
I didn't read that it said Hernandez. And what was the other name that it said?
¿Cuál es el otro nombre al que usted se estaba refiriendo?
Okay.
Excuse me, I didn't hear.
So, sir, when I initially asked you a few minutes ago who lives at this address, you stated a David Hernandez, and I believe you mentioned one other person lives there. Is that right?
Bueno, cuando yo le pregunté anteriormente quién eran las personas que vivían en esta casa, usted indicó que eran sus suegros y usted mencionó a otra persona. ¿Es esto correcto?
Sí.
Yes.
Okay. And if you know, who else other than David Hernandez lives at that address?
Y si usted sabe quién más aparte del señor David Hernández vive en esa dirección.
Su esposa.
His wife.
And do you know her name?
¿Y usted sabe el nombre de ella?
Juanita Guerrero.
Juanita Guerrero.
Is that her? And could you please spell, if you know it, Miss Guerrero's name?
Bueno, y si usted puede, si lo sabe, puede deletrear el nombre de la señora Juanita.
Juanita.
Juanita. Juanita. Guerrero. Guerrero.
Thank you.
Gracias.
And what were you doing at that house back on May 23rd?
¿Y qué estaba haciendo usted en esa casa en la fecha de mayo 23?
Una fiesta.
I was in a party.
And did something occur at that house on that day that brings you here today to court to testify?
Y algo ocurrió en esa casa en esa fecha que lo trajo aquí a que usted testificara el día de hoy. Excuse me?
Did anything out of the ordinary happen to you at the party that day?
¿Y algo fuera de lo común le ocurrió a usted en esa fiesta, en esa fecha?
No.
No?
Okay. Did you, well, let me ask you this. Did you ever, where were you, when you were at the residence that day? Where were you? What part of the house? Were you indoors, outdoors?
Bueno, ¿y en dónde estaba usted? Déjeme, yo le hago esta pregunta. ¿En dónde estaba usted cuando estaba en esa fiesta? ¿Usted estaba dentro de la casa? ¿Usted estaba fuera de la casa? ¿En dónde estaba usted?
Estaba afuera de la casa.
I was outside of the house.
Okay. And while you were outside of the house, was there ever any verbal or physical interaction, fights that you observed?
Y cuando usted estaba fuera de la casa, ¿usted escuchó que hubiera habido alguna pelea verbal o física?
No.
No. Were you ever, is this house surrounded by any sort of gate or fencing?
Y esta casa está rodeada por alguna clase de puerta o de reja. Yes.
And did you ever have occasion that day at that residence to be around or near that gate?
Y en alguna oportunidad cuando usted estaba en esa casa, usted tuvo la oportunidad de estar cerca de esa entrada o de esa reja.
Sí.
Yes.
And what were you doing by that gate?
¿Y usted qué estaba haciendo cerca de esa puerta?
No recuerdo.
I do not remember.
Okay. Is the gate in the front of the house, the back of the house? What area of the gate were you at?
Y esta puerta es en la parte de adelante de la casa, en la parte de atrás de la casa. ¿Esto en dónde es? It's in the front of the house.
Okay. And that's the part of the gate you were at, is that correct?
Y esta es la parte de la entrada en la que usted se encontraba, ¿correcto?
Sí.
Yes.
Was there anyone else around you at the time you were by this gate?
¿Y había alguien más que estaba alrededor suyo cuando usted estaba cerca de esta entrada?
No.
No.
How long were you standing by this gate?
¿Y cuánto tiempo cree usted que estaba parado cerca de esta puerta?
No recuerdo.
I do not remember.
Okay. Were you ever with your in-laws, David, that night when you were around that gate?
¿Y usted estaba en algún momento con sus suegros, con el señor David, cuando usted estaba cerca de esta puerta?
No recuerdo.
I do not remember.
Okay. Did you know everyone at the party?
¿Usted conocía a todas las personas que estaban en la fiesta?
Sí.
Yes.
Was there anyone at the party at that address that you ever saw that you hadn't seen before?
¿Y usted vio a alguien en esa fiesta, en esa dirección? ¿Usted vio a alguien en esa fiesta que usted nunca había visto antes?
Your Honor, I'm going to object. He asked if he knew anyone, was there anyone he didn't know? He said no, then he answered someone he met for the first time. He knew them at the party and implies that in some way, shape, or form they met previously. So it's been asked and answered.
Yes, but given the language barrier, I'm gonna allow the question to be asked again. Or to be asked. Would you re-ask it though, so it's fresh?
Sure.
Hay una objeción a la pregunta porque ya fue una pregunta que se le había hecho y que ya había sido contestada. Sin embargo, porque hay una barrera en el idioma, voy a permitir que se vuelva a formular la pregunta.
So, at any time you're at this party, was there anyone there that you saw or interacted with at any point that night that you did not know previously?
Y en esta fiesta, en algún momento durante la fiesta, usted interactuó con alguien o usted vio a alguien que no había conocido anteriormente.
Before you answer.
Antes de que usted conteste.
Your Honor, I just would indicate that I think that question needs to be specified. He's left it wide open that night. Things afterwards, before and everything, I think it needs to be focused to at the party before police interaction. Obviously, once 20 police officers who never showed up. There would be a number of people.
Objection sustained. Thank you.
Bueno, yo voy a presentar una objeción porque esta pregunta es muy amplia y no especifica un momento durante la noche en el que ocurrió la fiesta antes de que hubiera llegado los agentes de policía. Se sostiene la objeción a la pregunta.
Okay. Let's just take a step back. When you were on Anaroa that day, the 23rd, was it daytime or nighttime?
Bueno, entonces vamos a tomar un paso atrás en estas preguntas. Cuando usted estaba en la calle Anna Road, en esta fecha del 23, ¿usted estuvo allí durante el día o durante la noche?
Todo el día.
I was there the whole day.
No. Después de cuando empezó el party.
When the party began.
Okay. What time of day did the party begin?
¿Y a qué horas empezó la fiesta?
5 o 6 de la tarde.
5 or 6 in the afternoon.
Okay. And how late did the party go till?
¿Y hasta cuándo duró la fiesta?
12.
12.
Okay. And if you know, why did the party end at 12?
Y si usted sabe por qué se terminó la fiesta a las 12. Because there was a shotgun shooting. The interpreter made a mistake. It was the shooting.
There was a shooting?
Hubo entonces una balacera.
Me dispararon a mí también.
Yes, they fired at me as well.
Okay. You said they fired at you. So just to be sure, so at some point at this party on that night, someone shot at you. Is that right?
Entonces usted está diciendo ellos. Entonces en algún momento durante esta fiesta a usted le dispararon.
Sí.
Yes.
Okay. And was it towards the beginning of the party or towards the end of the party?
¿Y esto fue al principio de la fiesta o fue hacia el final de la fiesta?
Cuando empezó la balacera, al final.
When the shooting began, it was at the end.
Okay. And where were you physically at the house when someone shot at you?
¿Y usted físicamente dónde se encontraba en la casa cuando alguien le disparó?
Atrás de la puerta principal, a un lado.
It was behind the main door. I was on the side of that main door.
Okay. And when you say main door, where is the main door on the property?
Y cuando usted se refiere a la puerta principal, ¿en dónde se encuentra esta puerta principal en la propiedad?
Enfrente de la casa.
In front of the house.
Are you saying like, when you say main door, are you referring to a door that takes you inside of the home or a different part of the actual property?
Cuando usted se refiere a que usted estaba en la puerta principal, ¿usted está hablando de la puerta principal que tiene acceso a la casa o a un portón que está en otra parte de la propiedad? To the gate.
To the gate, okay. And so you're talking about a door to the gate, is that right?
Entonces usted está hablando que hay una puerta en el portón.
Sí.
Yes.
Okay. And is this the same gate you testified about earlier when you said you were standing by a gate during the party?
Y entonces este portón es al que usted se refiere cuando usted estaba diciendo que usted estaba cerca de este portón.
Sí.
Yes.
Okay. And I believe you said earlier in your testimony that they shot at you. Was it more than one person who shot at you?
Bueno, yo creo que usted anteriormente en su testimonio dijo que ellos le habían disparado. ¿Alguien más le disparó a usted? ¿Quién más le disparó a usted?
Nadie me disparó más que la persona que disparó.
Nobody shot at me except for the person who shot at me.
Okay, so just one individual shot at you. Is that right?
Entonces fue un solo individuo el que le disparó.
Sí.
Yes, yes.
And do you recall anything about what that individual looked like that night when they were shooting at you?
¿Y usted recuerda cómo aparecía este individuo cuando él le disparó a usted? ¿Usted sabe cómo se ve este individuo cuando le disparó a usted?
No recuerdo.
I do not remember.
Okay. Do you, did this individual point a firearm at you?
Y este individuo le apuntó con un arma.
Sí.
Yes.
And are you able to recall what area of your body that this gun was pointed at?
Y usted puede recordar cuál fue el área de su cuerpo al que este individuo le apuntó.
Mi cabeza.
At my head.
And what did you do once an individual pointed a gun at your head?
¿Y qué hizo usted cuando este individuo le apuntó con el arma en su cabeza?
Levanté mis manos y le dije 2 veces que no.
I raised my hands and I told him twice, no.
Okay. And what happened right after you said no?
¿Y qué pasó después de que usted inmediatamente dijo no? He fired.
And do you remember how many shots were fired at you?
¿Y usted recuerda cuántos disparos se le dieron a usted? One.
And did that one shot hit you anywhere on your body?
¿Y ese disparo le pegó en alguna parte de su cuerpo?
Sí.
Yes.
Where did it hit you?
¿En dónde le pegó?
Mi mano, bueno,
In my hand.
Okay.
Hand.
And let the record reflect the witness was pointing at his left hand here.
Bueno, entonces que el acta refleje que el testigo está señalando su mano izquierda.
The record will so reflect.
sí.
Esto es lo que se va a reflejar en el acta.
And this person that shot at you, was it a male or a female?
¿Y esta persona que le disparó a usted era un hombre o una mujer?
Un hombre.
A man.
And did you know this man?
¿Y usted conocía a este hombre?
No.
No.
Had you ever seen him before this date?
¿Y usted alguna vez lo había visto antes de este día?
No.
No.
And how far away from you was this man when he shot at you?
¿Y qué tan lejos estaba este hombre cuando él le disparó a usted?
Cerca de mí.
A few close to me.
Would it be within 10 feet from you?
¿Y esto podría ser a 10 pies de distancia de usted?
No.
No.
Somewhere between 10 and 20 feet?
¿Esto podría ser entre 10 y 20 pies?
No, yo que es la mano nada más.
No, the length of my arm. That's it.
Okay. So he was about an arm's length from you when he shot you, is that right?
Entonces él se encontraba a un brazo de distancia cuando él le disparó. ¿Es esto correcto?
Sí.
Yes.
Thank you. Now,
Gracias.
after you were shot in the hand, what did you do right after that?
Y después de que usted le dispararon en la mano, de que él le disparó en la mano, ¿qué hizo usted inmediatamente después de esto?
Me defendí.
I defended myself.
And how did you defend yourself?
¿Y cómo se defendió usted?
Le agarré su arma y lo golpeé.
I took his arm and his gun and I hit him.
And what happened after you hit him?
¿Y qué pasó después de que usted le pegó?
Lo tumbé al suelo.
I knocked him to the ground.
And did anyone else at this party come to your assistance?
¿Y alguien más en esta fiesta vino a asistirlo a usted?
No escuché.
I didn't hear.
After you knocked the shooter to the ground, did anyone else at the party come and assist you in any way?
Y usted después de que tumbó a la persona que le disparó, la tumbó al piso, ¿alguien más vino a asistirlo a usted? ¿Alguien que estaba en la fiesta?
No recuerdo quién, pero sí.
I do not remember who, but yes.
Okay. And at some point after you had knocked this person to the ground, did the police arrive?
Y en algún momento, después de que usted tumbó a esta persona al piso, ¿la policía llegó?
Sí.
Yes.
Okay. And when the police arrived, did you see where the shooter was?
Y cuando llegó la policía, ¿usted vio en dónde estaba la persona que le disparó?
Sí.
Yes.
Where was the shooter when the police arrived?
¿Y dónde estaba la persona a la que le disparó cuando la policía llegó?
En el driveway.
In the driveway.
Was the shooter standing or lying down?
¿La persona que le disparó estaba parada o estaba acostada?
No, acostada.
He was laying down.
Was anyone else laying down around the shooter when the police came?
¿Hay alguien más que estuviera acostado cuando la policía llegó, aparte de la persona que le disparó?
No.
No.
You said the shooter shot at you one time. Did you observe the shooter take any other shots anywhere else?
Usted dijo que la persona que le había disparado a usted una vez. ¿Usted vio que la persona que le disparó a usted disparó a alguien más o en otras oportunidades?
Sí.
Yes.
Where else did you see the shooter shooting?
¿A dónde más vio usted que la persona que estaba disparando disparó?
Tiró adentro del party.
He shot inside of the party.
Did you see if he was shooting at anyone specifically?
¿Usted vio si él estaba disparando a alguien específicamente?
I'm gonna object.
Yo tengo una objeción.
For him to be able to testify where the shooter is specifically shooting would be beyond his ability. He can say it was pointed and if there were people in the general area, but specifics, he can't answer what the shooter was specifically pointing.
Él no puede especificar en qué dirección estaba la persona que estaba disparando. Él podría decir que estaba disparando a las personas en general que estaban en la fiesta, pero no puede indicar específicamente a quién estaba apuntándole el arma y a quién le estaba disparando.
I would tend to agree with Mr. Defense Counsel.
Yo estoy de acuerdo con el abogado de la defensa.
Rephrase, Your Honor.
Yo voy a hacer la pregunta, formular la pregunta de otra manera, su señoría.
Did you observe the shooter shooting in the general direction of anyone else at the party?
Y usted vio a la persona que le disparó a usted disparar en la dirección general de las personas que estaban en la fiesta.
Sí.
Yes.
And in whose general direction did you observe the shooter shoot at?
Y a la dirección general de quién estaba disparando el señor que disparó.
A la propiedad de mis suegros.
At the property of my in-laws.
Okay, thank you. And your in-law, when you say in-laws, you mean the two people you referred to as your in-laws earlier as owning the house, Mr. Hernandez and Miss Guerrero, is that right?
Y usted se refiere, cuando usted habla de sus suegros, a las personas a las que usted se refirió anteriormente, que son sus suegros, al señor Hernández y a la señora Guerrero.
Sí.
Yes.
And when you observed the shooter shooting at your in-laws, was this before or after the shooter shot you?
Y cuando usted observó la persona que estaba disparando en la dirección hacia la casa de sus suegros, ¿esto ocurrió antes de que le disparara a usted o después de que le disparara a usted?
Antes.
Before.
Okay, thank you.
Bueno, gracias.
Let me just interject for one moment. Are you translating what is being said here?
I am allowing him to listen exactly what she's saying.
Right.
Except when the defense lawyer speaks, then I interpret for him.
Thank you.
And did the shooter say anything to you at any time before or after he shot you?
¿Y la persona que le disparó a usted le dijo algo a usted antes o después de que le disparó?
No recuerdo.
I do not remember.
I have no further questions here.
Yo no tengo ninguna otra pregunta, su señoría.
Cross-examination.
Van a hacer contrainterrogatorio. Gracias, su señoría.
Mr. De La Cruz, if you don't understand the question I'm asking, just let me know and I'll rephrase it, okay?
Señor de la Cruz, si usted no entiende la pregunta que yo le estoy haciendo, por favor hágalo saber que yo se la voy a formular de otra manera. Okay.
Have you been convicted of a crime involving theft or dishonesty within the last 10 years?
¿Usted ha estado involucrado en algún crimen que tenga que ver con robo o alguna acción deshonesta en los últimos 10 años?
No.
No.
Do you recall how many shots you heard that night in total?
¿Y usted recuerda cuántos disparos escuchó usted en total?
4.
4.
The shots you heard, did they all come from the shooter?
¿Y los disparos que usted escuchó todos vinieron de la persona, del tirador?
No recuerdo.
I do not remember.
Do you remember if anyone else shot?
¿Usted recuerda si alguien más disparó?
No.
No.
You don't remember or no one else shot?
No
¿Usted no recuerda o usted no sabe si alguien más disparó?
No sé quién más disparó.
I do not know who else fired.
Did someone else fire though?
¿Y alguien más disparó?
No sé.
I do not know.
And you were out by the gate for prior to there being shots and after there being shots, correct?
Y usted estaba cerca del portón antes de que se escucharan los disparos y después de que se escucharon los disparos, ¿correcto? Yes.
Did you hear an argument between the group and the person who was the shooter?
¿Y usted escuchó algún argumento entre el grupo y la persona que disparó?
No.
No.
Did you see someone in the group physically attack the shooter?
¿Y usted vio a alguien en el grupo que físicamente atacó al tirador?
No.
No.
You indicated that when you noticed the shooter, he was within an arm's length of you, correct?
Y usted indicó que cuando usted observó al tirador, él se encontraba a un brazo de distancia de usted, ¿correcto?
Sí.
Yes.
And he pointed the gun, as you indicated, at your head.
Y él le apuntó el arma a la cabeza, ¿correcto?
Sí.
Yes.
And fired one shot at you.
Y él le disparó a usted
Sí.
una vez.
Sí.
Yes.
And hit
Yes.
you in your left hand.
Y le pegó en su mano izquierda.
Sí.
Yes.
Thank you. Nothing further.
Gracias, no tengo más preguntas.
Can you redirect?
¿Usted quiere hacer un interrogatorio nuevo?
No, Your Honor.
No, su señoría.
Thank you. You may exit the courtroom.
Bueno, usted se puede retirar de la corte. Excuse me.
Just sit it there. Okay. Thank you. Any further witnesses for the prosecution?
¿Algún otro?
Mr. Konecki, did you have any witnesses to
No, Your
present?
Honor.
Okay, is there a motion?
Yes, Your Honor.
Your Honor, could this interpreter be dismissed since
Yes,
there's
and I
no more
did-
witnesses present?
Yes, and I did sign your paperwork.
Okay. Thank you.
You're welcome.
Would you like me to wait, Your Honor, or just proceed?
You can proceed.
At this time, the people will make a motion to bind over the defendant's case, Mr. Ariola Aguilar, as charged. I will do my best, because this is a Helen part, to try and recall what happened the first day and connect it to today in my argument.
Keep in mind, I did take very copious notes, so it's not as if you should feel pressured to
Very, very well, Your Honor.
regurgitate the record.
What I will do is I will reserve any of my argument for rebuttal.
Okay.
Your Honor, we would simply object without argument, understanding that any sort of self-defense argument would necessitate a bind over, so objection, no argument.
I don't feel the need then for the prosecutor to respond with a rebuttal to that bind over opposition, but certainly there has been sufficient testimony. As I indicated earlier, I did take very copious notes at the onset of this examination as I went through each of the allegations that are set forth in the complaint and made various check marks with the testimony that was presented by the various witnesses. Coupled with the testimony from today, I am satisfied that the prosecution has met their burden here today. The burden on the prosecutor, sir, is to establish by a probable cause standard that crimes were committed in the city of Detroit, county of Wayne, and that you probably committed those crimes. With the testimony that has been presented, I am satisfied again that the prosecution has met that burden. So with that being said, that as it relates to counts 1 through count 17. They will all be bound over to the circuit court for further proceedings with an arraignment date of July 23rd at 9 a.m. Certainly, once this matter proceeds to circuit court, provided it's not resolved short of trial, your attorney will be permitted to explore whatever defenses he feels are appropriate. And is there anything further either from the defense, Mr. Konecki, or the prosecution?
Not from the prosecution.
Mr. Konecki?
Nothing further on.
Thank you. We're all set here.
I'm sorry, Aaron, if I could just have 1 second. What's your? You emailed me the bond report. I think it's below, so I was just hoping I could look at it briefly, just see.
There's nothing in the file.
I think if you're referring to the same thing I got today, it just says they couldn't conduct one because of the.
Oh, okay, because was that the same, okay.
Yeah, I just emailed it to both of you.
I'd ask if the court would re-refer it in hopes that next week they'll have the necessary people to be able to interview my client and make a bond reduction request.
Okay. I will make a notation for another DSU referral.
Thank you, Judge.
Thank you.
Thank you, Aaron.
Thank you, sir.
All set.
Yes, we're all set.
And we'll open the address your bond now.
And I got us another sheet.
Oh, yeah.
I'm gonna try to set up a visit for us before.
All right, boss.
Oh, no, you're fine. Probably the one I was sitting on.
Thank you, Rana.
Thank you, sir. Did you get your paperwork?
I did.
Okay,
Thank you very much.